I spent like 45 minutes on that, and then these last 15 do call 3 on him.
Nice. Yeah, that's smart.
Because I was like,
that's smart.
I put the head notes in case I couldn't get back to it, but I was like,
right.
Oh my god, I don't care.
You're so dedicated. I'm really proud of you. Sit there and read that nonsense.
Don't see, clearly it doesn't matter. Especially if you did better than me on multis, which I'm sure you did because you always do.
If you read them slower, you probably would get a higher score. Do you find the one that you think is closest, and then after that you delete all the ones that are wrong and see if you're doubly left with one answer?
What?
So what you do is you read the question, you seek for your guess, you seek the answer that's closest to your guess, and then you flip into a process of elimination and eliminate all the wrong ones to make double sure that you end up with the correct answer.
No.
Because
I read the question. Because I don't read the call first because I don't really give a fuck what class I'm in.
And then you just.
And then I read the question. I don't even look at the answers, and I think in my head, okay, it's this. And then if that answer's there, I choose it.
And
then if it's not there, then I'll read through all the answers, and I'll be like, this one sounds more right, and I don't go back.
Yeah, that's pretty much right, except for the second set. I do always read all of the.
Well, sometimes I do, but usually I don't.
Yeah.
Like, especially if I read it and it's like a yes or no question, I'll be like, no, I'm not going to look at the yeses.
Right. Because it can throw you off if you already know it's no.
It is, actually.
He's probably walking in right now.
So the case starts on 473 on business organizations. The facts don't end until 480. I already read for this stuff.
You read this class.
I was reading for business organizations.
You're such a good student. I'm so proud of you.
Well, no, business organizations is tomorrow, and I'm pretty sure our reading goes to like 520.
Oh gosh.
The entire chapter. Yeah, it goes to 520, and I'm only on page 480. So I still have 40 more pages to read, plus all of community property to read. All the time in the world to read 400 pages a week.
What do you guys think of the Armstrong case? Brand new, 2015.
Which one was that?
566.
566.
That was
the Medicare, Medicaid Act.
These are all like.
That was a 5-4 decision.
Yeah.
Yeah.
These are all just so convoluted. Like, we know that we said that we could get sued, but we didn't write it in the right way, so we can't get sued.
This is for Medicare, which the Medicare covers so many of. Basically, if you work at a lot of institutions, you have to use Medicare, and they were basically undercutting the fair costs associated with everything, and the court held that you can't sue them for that. You can't sue their budgetary deciders for their decisions to, I don't know, it's interesting.
Hey, it's an interesting
It
case.
seems like you should have standing because, I mean, they're deciding how much money you can, like it shouldn't just be like an immunity, out the door. Like they've more than interjected themselves into they're choosing the price. There's more than there's easily a special relationship, I think. So, but yeah, Scalia says that there's no private right of action, period.
Yeah. But the Constitution, this is a private.
Yeah, I don't know how the supremacy clause came into it all. I'm still not.
The clause creates a rule of decision That's the supremacy clause. Courts shall. That's a pretty strong one, don't you think? Shall.
I like words up like that.
Yeah. Regard the Constitution and all laws made in pursuance thereof. That's the supreme law of the land. Why do you have to go any further than that? But he does. Interestingly enough. I don't know. It's a new case. That's why I'm saying now it's 2015. Just so we are clear, it's Medicaid. Medicaid
Yeah,
is for
Medicaid is state
women
for-
and for children. So he's picking on women and women who need health services, mostly for childbirth.
Right.
Like that, reproductive services, and children are Medicaid. So every time you hear them cut Medicaid, it's a separate program, and
Right.
it was created just for, well, not really just for.
That's for poor people.
Yeah, it's California's
Medical.
statute for poor
Right.
people.
Yeah, pretty much.
In California, it's Medi-Cal, and every other state, it's Medicaid.
Right, but we have our own. Because we're rich here.
But every state has their own, they just get subsidized from the federal government.
I
don't they?
leave this out on this we're rich here,
Well,
so.
that's what the case is about. I mean, they're trying to get them to take funds. So, that's essentially what Medicaid is. So, okay, well, I'll give you all a couple minutes here to look at your papers. So I guess you two take a couple seconds. And we'll go over obviously it's not very long. Cost. They actually got it. Of all things, they actually, this book is mostly the same as the last one, except they cut out a huge chunk
And good for
From this chapter?
from this chapter.
What else is there to say? The government doesn't consent, so you can't sue them. I mean, I don't know how many notes they needed to say that in. In ever escalating scenarios, judges are immune, even if they drag in the coffee guy, even if they drag in a person that they pulled over themselves, judges are immune.
Alright, I didn't say tonight was a great class. Don't get me wrong.
No, I'm not, I'm just saying, I don't know how much more they needed in this chapter.
You need at least 30 ways per case on how to do something.
Well, no, this was literally what all the notes were.
Because I mean, it is literally if they consent. I mean, it's almost impossible.
Yeah. I was like, I just kept reading through the cases going, well, maybe there's an exception, maybe there's an exception. It's like, no, it's just, no. Okay, this is a little bit administrative, but it still has to deal with their powers. No.
Pretty much. But the Bivens case was pretty interesting. You liked that one, right?
I can't remember names.
That was not the one about the 6
Oh yeah, the
agents.
6 unknown agents.
yeah.
Well, he wants to serve agent.
That's a very interesting case. That one kind of opened the door for money judgments. I think to some degree, because before that it was like complaining. Accent was just a judge,
We're just getting swatted all the time. People sprinkling themselves.
Yeah, well, but if they wanted to be sued for slaughter, they'll let you know. That's the nice one. Pretty much. You'd kind of be surprised that they do let some suits go through, particularly under the Torts Act from time to time. The government actually will let some suits in the interest of, well, if they're going to take a really bad hit in the media, for doing something pretty, not necessarily bad. I mean, it's more like negligence and stuff. They let those go through sometimes when they're really the only people they can get relief from. So weird cases like that happen. Believe it or not, a hot spot for that is the where they can agree or not agree. It's a hot spot for that is at airports at the immigration, because the federal government actually owns the immigration for that's federal territory. And so, believe it or not, sometimes people fall into support and all sorts of crazy stuff. And they can agree to be sued or not. And usually, believe it or not, usually they say no.
Really?
Yeah, usually they just say, do that, and they say no.
I
A lot. So, but sometimes they do. Sometimes they say, yeah, sure.
Oh, is that only when they think they can win? When they get sent to
That I don't know. It's very funny though. I did have one case against. We worked on part of it. It wasn't my case. It was not the attorney's. But I worked on that part of it, figuring I could maybe figure out the federal government's angle on all this, and they were just, I mean, I'm not saying their training was bad.
I got really mad at Heathrow
But-
once. So I had bags checked from Israel to LAX, and that was good. You know what I mean? Because I had stuff in there that, like, you know, they're like souvenirs, like including like wine and stuff. That was like cool stuff. And it popped up. They took my bags off at Heathrow, like in the place I was going to go through, and then I had to throw all my souvenirs away because they wouldn't let me check like weird some stuff.
Oh.
Yeah.
Yeah.
They wouldn't let me recheck it. It was like a big issue. They wouldn't let me, like, I don't know. Yeah, sorry, random aside.
You're bringing to
This was
do
at Heathrow, and
Yeah.
you were coming from where?
From
I
Israel.
thought you said Israel. That's the safest place on the planet to get on a plane.
Oh.
That's true, by the way. I'm not
Israel?
being facetious.
They search everyone.
Yeah, I mean, they search everyone, and it is the safest airport in the world. So, by far. I mean, nobody does know from there. You know, they squeeze your toothpaste tubes over your life every night. You know, too bad.
Is that a euphemism or actually?
I don't know. They were cool, I thought.
Yeah, they're also the only. They're the only airline that
They make you open your own bag in front of them, like weird stuff like that.
yeah, a lot of weird stuff.
Like
Plus,
they don't open your bag, they like ask you
they're
to do
the
it.
only armed pilots in the world,
Oh.
and they're required to be armed. They can't fly without arming themselves. They have to have a weapon, and the door is still reinforced. And there's a button that if they hit the button, you can't get in there. There's no way.
Isn't that how American ones are now?
I think American.
I think after 9/11, that's how they changed them to do it that
Now
way.
it's like, well, because it's considered a deterrent. I mean, the terrorists would know that they couldn't get in, right? And it's like, because they can just, not good for the passengers, I suppose, but, you know, they could just hit that button and then there's nothing, I mean,
Looks
and
like
they
you
can't
can-
open the door. I mean, it's sealed. There's nothing they can do either, so,
Yeah.
you know. So it's kind of a deterrent on one level, but on the other level, it's kind of,
Because I know every time I fly, like when the pilot gets out to go to the bathroom, there's usually like one flight attendant that is like right there in front of the door while they open it. And then once it's shut again, she leaves. So then she's and I asked her, I was like,
You're so scary.
I'm like, are you gonna protect us? She was like, no, but she's like, while it's open, somebody can get in there, but while it's closed, you can't get in there if you want to. She's like, I can't get in there even if I want to. They have to let us in.
She's more like a visual guard, probably.
Yeah, she's more about I can slam that door shut if I have to
And
if I
press the
see
button.
you coming.
Exactly.
let me amend that. I can jump in there and shut it.
Yeah.
That would be the move. That would be the kung fu move. But yeah, but it's pretty interesting. But that Tel Aviv, El Al is the safest airline in the world by far. I mean, it's nobody close. So that's second. So
Also pretty.
I wasn't flying. I was flying Virgin though. I think.
oh
But it just was out of whatever.
It's not at the airport though, so
yeah, still you
I
probably
can't imagine Tel Aviv because I mean that is like the most like
It's the most comfortable place.
terrorist-stricken
No, it's-
area, isn't it?
No, man.
Aren't they always trying to attack Tel Aviv?
Yeah, there's rockets that come up once in a while. The alarms went off a couple times when I was there. They let us push this bag, and they have air raid sirens that shut down the whole city, and it's kind of cool. But I've never felt safer there, honestly. As long as you don't mind like some 17-year-old kid walking around with an AR, then you're if you're comfortable with that, like if that's not scary to you, then you'll always feel comfortable. But if that alone is scary to you, it can feel scary. You know?
oh yeah.
So,
Oh, well, I know.
yeah.
Yeah. So
What's that?
interesting.
You see my gun, you have a right to do your activity. That's my thing. Sorry.
But so wasn't Bivens before the U.S. Tort Act, anyways,
Before the U.S. Tort Act.
or like the one where it?
That's been around for a while. There's been a version of that for many decades now.
Because
I do believe.
if it wasn't, why didn't the U.S. government just step in as?
The Torch Cleansing was the first one. Was the OSHA case.
Well, why don't we wait it? Let's do the, what you call it first.
I just don't understand why they wouldn't
70, yeah, that's not
step in as respondeat superior and just stop everything. Like some of the note cases that they could do.
I think.
Like, okay, we're gonna come in, they're a federal agent, they work under the government, we don't consent to be sued, so
Okay,
sucks to be you. But
yeah. Well, we'll get on to some other things too. It's not as bleak as it sounds.
here's a good question.
Anyway,
Better go back in.
guess everyone got their answers and everything.
Mm-hmm.
Ready to rock and roll? Okay, let's go ahead then.
Great.
Yeah.
It's been a crazy week, man. It is.
So I got the first one.
Sure.
All right. So this is a case where
What are you
they
guys doing? No. We're going to do the test first.
Oh, that's why I collected them. I didn't think you were gonna do the test.
Yeah, then let's take them back.
Of course, I was just curious what you thought about that in case they written the book.
Ah.
I guess
Oh, George.
I thought you were passing them out.
No, I was taking them out.
No, let's
Because you're like, let's go through the cases in order, actually. And so I was like, okay, let's.
No. Let's not do that. Let's do this first, because otherwise there's no class. So, they're very short class. Okay, so, right, so, bottom line is,
Longest question
yeah,
ever.
this is like the racehorse.
I put it last because I saw it and I just like, I'll give that 1 hour at the end. You know, I'm not going to sacrifice my other classes.
If you can do this one, I honestly don't think you should be super worried about the bond. I mean, if you did a pretty good job on this one, then that's pretty good. I mean, I would have trouble finishing this one in time.
I didn't.
So you didn't really see, but I'm.
There's a few issues that I realized.
So these are the ones that scared the hell out of me. Or back in the old days, they could not just write them, so they're not scary. I could probably get a 70. But this is kind of like this is a very this is a snapshot for everybody. You know, you should be able to do a pretty good job on this one. Not great, you know, but pretty good. So, although, you know, several were quite good, but this is one of those that would be on the bar, just heartbreak deal killer. Heartbreak deal killer, absolutely. And it's one that the bar loves to test on, because think about it, they love, injunctions are so easy because there's 4 different places they can put it. They can put it in a contract question. They can put it in a tort question. They can put it in a civil procedure question, and they can put it in a remedies question. And it comes up, you know, more often than you think. And every time it comes up, half the group just freaks out. And, you know, it's like, after so many years of doing this, you can only throw up your hands so many times, right? And then you're just like, okay, I told you, make sure you know how to do, you know, TROs, right? Prelims and permanent injunctions, because it comes up a lot. You're certainly going to get multis on it, you know, in civil procedure, if nothing else. I guarantee it, if not in remedies. So again, you see how this one crosses over so many different areas. To actually not know how to do this is suicidal. Oh, what's this? Oh yeah, that's right. You guys had MPs.
Oh, yes.
Forgot about that.
Well, like, I want to know. Maybe.
Torturous.
I'll get yours, my mind. What did he get?
Yeah. So, you know, so this would really be, this one would be, yeah. This is where you can kind of think to yourself, okay, you know, how well is my 4th year really going? Right? How good am I doing? How bad am I doing? How indifferent am I doing? Et cetera, et cetera, et cetera. Because you should be able to handle these, right? I mean, I know this sounds, you know, this class is not easy, but it's just remedies. You know, I mean, you have to know remedies. That's what I mean by that. It's just not an option. This is one of those areas where students historically do very poorly on the bar, very poorly. And I remember when there was a question that was very similar to this one. There's been a couple, that have been very similar to this question, mostly about tomatoes.
Those are Veronica's, like, she's like, did you get the one about tomatoes? And I was like, no, we got the one about coffee beans.
And everyone kind of looked at themselves. The tomato is, it's called the famous Borelli question, because it was this, you think this is long? It was a UCC question that sort of followed kind of this one, but it was even worse. And people just went, you know, because here you got hit with, you know, a full-on UCC question. Things are going sideways 6 different ways, right? And then there was this, you had to do TRO, prelim, and permanent in all 3. So, and people were just like, you know, it was like they were having, you know, it was, people were literally having spasms on the floor, I think, on that one. So again, one of those real deal killers. So you have to know, you see what I'm saying? You just have to know injunctions. They just love to throw them out there, you know, and you're going to get one. I mean, not necessarily on the essays, but there are multis, plenty of multis on injunctions. And yet for some reason, you know, again, it's just one of those weird blind spots that students have. Yeah. So take it for what it's worth, right? You're in your 4th year now, so everyone should be able to handle these. You should be able to handle the, I don't know what you guys got, by the way. Multi-states, I have no idea. But I haven't looked at your grades on that yet. I figure if you're, you know, okay, I'm okay. So we'll let me know if you're not.
A little higher would have been better, but
Well, of course.
you know.
Did anyone get 20 out of 20? All right then. We
Almost in community property.
You almost
So-
so, me for
Again, my big worry is that, and there's still plenty of time, so whatever you do and do not like about your grades, there's still time to fix it, but I wouldn't wait a whole lot longer. I mean, time gets really short, and I think I've mentioned this before. I'll certainly mention it again, but as and again, I commend you. You are all like me. You know, I went back to law school. It's funny, someone asked me this the other day. They honestly did not know this. I went back to law school at 36. I did not go from undergraduate to law school. I had another life that was not in law. And, you know, I went back to law school at 36. And what I learned, which is what you're learning, which is what pretty much everyone in our position learns, is time's not your friend. And there is a point, I'm telling you, and it's not the day before the bar, but there is a point of no return. There really is. And it's about 2 months out. To be honest with you, there will come a day about 2 months out. I could probably see it. I don't know if you can see it, because again, you're your first time taker. So it's hard to see, but there actually is about a time, about 2 months out, where if you aren't at a certain place, you're already dead. There's almost literally nothing you can do. And the reason why is because you don't have enough time. What you would have to do is quit your job, lock yourself in a room, and study for 18 hours every day. If you did that, I would say maybe, maybe you'd have a shot at it. But actually the time to be prepared really realistically is about 2 to 3 months out. You've got to be in a certain space, because you've got to be able to live your lives and take the bar, right? You're not just going to stop. Although it is kind of nice that you don't go to law school. So you see, that's kind of cool. You do have that little break in there, which actually is very nice. But if you don't have, so you get to make that time up. But again, you're competing, and it has nothing to do. I will repeat this. I think I'll just put this on my tombstone. It has nothing to do with intelligence. It has to do with you're going up against kids who have nothing to do. Okay, that's just the way it is. That's society, right? You know what? I wish my mom would have brought me into Harvard. You know, that's just the way it is. And, you know, I find that really funny that, you know, this is something that gets them all upset. And in fact, I'm telling you that, you know, class, whatever you want to call it, elitism is completely built into the college system in the United States. That's a joke. You know, 26-year-old who is still technically living off of their parents and has nothing to do for 2 months except do library for 18 hours a day, it speaks for itself. Right? It just does. It certainly doesn't mean they're more intelligent than the persons in that room that are not in that position. It just means that this is the way society works. Now, that's not necessarily a horrible thing. Don't get me wrong, by the way. I mean, I know this sounds rather odd, but, you know, to some degree, you get what you work for, you know what I'm saying? So, to some degree, that really doesn't bother me that much. I mean, it never bothered me that I didn't have, you know, that in my life. Of course, I grew up knowing that wasn't going to happen, but you know that's another story for another time. But you know, again, statistics tell us that your best chance of passing the bar is the first time. Okay? That's just the way it is. Again, it's just sort of the way it is scenario. So every time, you know, why not just make the effort now? Right? Make the effort now. Yeah, I don't even know what grade you're talking about, classes or anything. But in the 4th year is really the best time to get into this mode where, you know, when you get out, you'll have this 2 months, you'll have this chunk of, you know, change on your hands, so to speak. And just use it wisely. But you're going to have to be in a position. Okay? You have to be in that position. And if you're not, it's just, again, it's sort of like you're running a race that you know you don't have enough gas to reach the finish line. Why are you doing that? It doesn't matter how much you try. You know, if it's 500 laps and you have gas for 450 laps and there ain't no more, there ain't no more. And the bar just, it's one of those things where you're just better off, again, being nighttime learners or secondary learners or whatever you want to call yourselves. You're just better off just thinking of it as one piece of a whole puzzle. You know, I mean, and believe me, you know, you. I mean, again, I don't mean this as you know, flippant as it sounds, but trust me, you know, it's like there's, well, if I could just work overtime this week, I'd have money, and I said, okay, don't do that. You're gonna kill yourself. Okay, I almost killed myself, quite frankly. It doesn't work that way, and so. What it does come down to, though, this is very important. This is really the only point I want to make today, because again, we're still way far out. Okay, we're way far out. But here's the point I want to make today. It's your life. If you want to be a lawyer, you'll be a lawyer. If you don't want to be a lawyer, you won't. But it won't start the day before the bar. It won't. You know, it starts when? Now, like right now. Right now, right here, right now. Start acting like you're the person that's going to pass the bar. But that requires you to make time for this. It just does. Okay? Now, again, I don't want anyone to freak out. Nobody did that bad. I'm sitting there and, you know it's bad. You know, you want to know when it's bad? It's like when I say, I have to see you with break. That's bad. Okay, that means I really see a problem here that needs to get fixed. You guys can have a break. I'm not going to bug any of you, okay? But you're in your 4th year. Time is growing short, right? We good? Everyone good? Mm-hmm. Again, you can all do this, I'm telling you. But it's a matter of preparation. It's not anything else. And it's very, and trust me, believe me, I know how difficult it is to be in your 4th year. You know, and I had a full-time job, you know, and the thing is just very quickly, I'll tell you this quick story if I haven't before, because you guys never tell me when I tell you stories twice. Everyone else does, but you guys never do. Thank you. It actually makes me feel good. But, you know, I actually was working in I had a good job. I was fine, you know, and, you know, but I wanted to be a lawyer. I wanted to be more than what I was doing, like a lot of people. And so again, I commend you all for being here. You never see me pick on anyone at this law school, do you? That's actually why. It's like you're trying to make your life better. I have no problem with that. I like people actually try to make their lives better. I actually admire them to some degree, as opposed to people who just whine about their whole lives for the rest of your lives. Strangely enough, that's like the one thing you don't get at law school. Nobody gives law students credit for that, but because you're doing something about it, and so you're being proactive, which is great. The thing was, I had arranged with my employer to take 2 months off, right? They said no. I said I quit because I knew what I wanted, and I knew that I couldn't do it. I knew I couldn't do it. Now, again, it doesn't mean that you're in my position, but keep in mind, I'm a slow reader. I'm a slow writer. I went to a law school that I never did a multi-state a day in my life. None. Zero, zip, zilch. And my essay writing skills were nowhere near your guys. Nowhere, right? First time I took my first Barbary class and I did my first 100 multi-states, I got 20. 20. The clock was ticking. There was 2 months to go. I knew I had one shot, which was to basically do between 15 and 18 hours a day. I did it and I passed. But that's why. It wasn't because I was smart. Well, I was smart. I was smart enough to quit. That was the one thing I did right. Otherwise, I guarantee you, I look back now and I'm like, I guarantee you I wouldn't have passed. There's no way. There's no way. And so that's why, when I say things to you, it's like, you can take it for what it's worth, but I'm no different than you. That's why I know. I know that I couldn't do it. I couldn't. There's no way. There's no way. Plus, I was a terrible student. See, that's what makes this all so funny. I almost got kicked out of high school for truancy. I was way back when, bad student, I see these people from, these young adults from, Amistad and stuff like that, and they all think they're bad. And I'm like, if you went to my high school, we would have, you wouldn't have lasted 5 minutes, quite frankly. I don't know what to tell them, So, very different back in those. I mean, not back in the 60s, but nobody knew what they were doing back then. So they invariably always picked the wrong thing, but it's just how life goes, right? Anyway, but that's what I want to see. I want to see all of you come out. I want to see all of you pass the bar the first time. But again, if you, just, it just comes down to how much you want it. That's it. If you don't want it, you won't pass. I'm telling you. That's another thing that I happen to know. You have to really want it. Like, this is what I'm going to do. Not maybe. I can't speak for any particular student here. Won't. But over the years, there always are students that I know aren't going to pass the bar. I know they're not going to. I know that sounds weird. They could pass the bar, but they have to change their attitude. It has nothing to do with how smart or how not smart they are. It has to do with how much they want to be an attorney. Okay? So let's keep that in mind, that this is the goal. Let's keep in mind that this is a laudable goal. This is a good goal. Become a lawyer, right? Okay, good. Anyways, with that said, so this is a good kind of wake-up call for everybody. Plus the multi-states as well. Remedies is just a good way to know where you're at. You should be able to handle a remedies question. You just should. Those will be the ones that pass will be the ones that handle the remedies questions. The ones that don't are the ones that won't pass. That much I can pretty much tell you. So, just so you know, that this is one of those areas. There's a couple of them that just, eats it. Landlord-tenant. Why, landlord-tenant is the most tested subject matter on the board.
If I got one of those, I'd be like,
Well, you won't be that way because I'm going to get a hold of you.
The thing is, I just don't know how to approach one of those.
I will show you how to approach it. I'm going to write that down in my memory book. We're going to do this. And they just had a landlord-tenant question. And I had 2 students say, what a shock, they had landlord-tenant.
It's a simple, like, file your unlawful retainer and kick them out.
Well, I told her, just, get, how's that for conviction? That works in Texas. Right? Get off my land. Anyway, but with that said, so again, that's another one that just, the bar just keeps throwing them out there. They hadn't had a murder question on the bar since 2005.
Well, yeah. I mean,
how much do you really want to put into that?
everybody tested on in law school.
Yeah.
It's all that you learn in a regular in a regular 1 semester like law class. About half of it is murder.
Yeah.
Like at a regular law school.
Yeah.
About half of it is murder, and the rest are like, and memorize all these crimes.
Yeah.
It's
And
like-
make sure you get specific intent. They throw that in there sometimes.
Well, that's the point of learning murder, is to learn the different levels of intent.
Yeah, malice.
Yeah.
That's true. So, but again, they don't test it. So, I mean, not that you shouldn't know it, and yes, they do on multi-states. When I say they don't test it, that means essays. But there's just these different areas where you can just sort of see what it is and what it's not. And our goal is just to be boringly average in everything. That's fine. I have no problem with that whatsoever. That's actually the person that will pass. So, because they won't trip up. The bar is not really best by that, 4 out of 5. It's not. It's the person that does average on all 5 is the one that passes invariably. Always, every time. It's just math. That's all it is. So, anyways, but we'll, do it. And again, I don't think anybody should, sit at home and say, oh no, what did he say today? Or anything like that. Don't. It's no point. We're too far out anyway, if even nothing else. But I still, but I want to see better. Okay, I want to see better because you're getting there now, right? I mean, what's this? This is March, guys.
I think there's a couple of these wrong on corporations.
Oh, I wasn't even looking at those ones yet.
Which ones were you looking at?
Remedies. I got questions about remedies.
Oh, you mean because you're in the remedies class now? Okay.
Well, like the business ones are bad. Like agency by, and the answer is clearly ratification, and they wrote indemnification. Like when the person misrepresents themselves and the principal then accepts the unauthorized act.
Yeah, that's ratification.
That's and he's saying
What question number is that?
it's indemnification.
What's the right answer?
I put A.
It is
I
A.
put A.
And
Okay,
we
so the
all put
question
A.
though.
And there's also another one. Common stock allows a holder to do all of the following except, and the answer is have a voice in day-to-day corporate decision making.
What's the number?
Like a common stock holder does not have a voice. 46. 46.
I got that one right.
What'd you guys put?
Oh wait, no, I didn't get that one right. I put A.
46 should be A.
I put A, so yeah, question here.
Okay, questions on that. Sorry, what were your questions about remedies?
So
Well, how did you, I mean, you don't have to give your scores or anything, but did you guys do okay? I mean,
I got a 70 in remedies and business associations, and then whatever an 18 out of 20 is in community property.
I got the 14 out of 20s in business association remedies and 19 out of 20 in community property.
who teaches community property right now?
Keller.
I gotta take her class. Okay, fair enough. Wow, that's good, by the way. Okay, wow, okay, I'm feeling a little better, actually.
So for question 27, I chose C because
Which one?
for question 27,
I was right, man. I was right, man.
Shush.
We're good on that one.
I thought punitive damages are not allowed in a contract case.
Well, they are if there's an underlying tort.
Yeah.
That would be, I mean, I don't even know what you're talking about. I'm
So-
telling you that's the law without
Is-
even looking at the question.
Deceit a tort?
Yeah.
What tort? It's deceit.
Fraud?
It's like fraud.
That's right.
Really?
Huh.
Yeah.
I thought even if there's misrepresentation, your remedies are rescission, reformation, or mainly reformation, but I think you get punitive damages on a contract.
It's possible that there's an underlying tort. Any contract that was fraudulently induced, you can get punitive. I can tell you that for sure.
I swore I had 7 class. regardless.
Well, I didn't say they were easy questions.
These questions are too long for me to actually like sit here and like bring them to care about whether or not
But these questions tend to be long, because remember, they have to take you all over the remedies, so, these are long questions, but get used to them. I mean, remedies questions tend to be long. The contract ones tend to be a little longer than the short ones, but they tend to be pretty long, so.
Okay, let's do 23 then. That's the first one that I missed here, and I think I can argue that that's a little bit. I believe it's
Thanks.
I was waiting for these right too.
I guess that's it.
No, I had A.
20.
Did you have A?
23. I put A.
Like both are wrong.
And I just think that latches. This is way too remote to say that no, because latches. You know what I mean? It's like
All right, well,
that's not best answer material.
All right, do you guys want to make a? I'm gonna tell you what I'm going to do. Let's this is the cases. They're all distilled from cases, so you can actually. I'll give you the case list.
Okay.
So you can read the cases. How's that sound?
Okay. Well, I mean, but
Because I mean, again, I like ones like this one that I did because they're just distillations of cases. I can't be wrong.
okay. All
But I
right.
will give you the case.
Yeah, so like 23, for example, it's 10 years, and I think that latches makes perfect sense. I just think that best answer is yes, if they can prove design defect, and then a second best answer would be C, no, because latches. So you don't pick the defense, an equitable defense, before you pick saying yes, if they can prove design defect. Like, that's the better answer.
I think latches just because none of the other three made sense. Like,
Well,
design
you can-
defect,
you can
it's been
use
10 years, man.
You can get strict liability for design defect.
What's the SL?
Do you feel like we had that?
What's the SL and products and this kind of thing?
I don't know, but the thing is they're arguing that
Didn't we have that pool? Didn't you tell us about that pool pump case where the bolt stripped so much? Or was that an MCLE where we learned about that case? Where they sued for product defect because the screw in the pool pump was defective, and because of the pressure that was in the pool pump, it exploded, and that pool pump was like almost 20 years old, and they still got it.
if you can prove your design defect, exactly. It's essentially a strict liability for a design defect.
I can't remember if you were the one.
If there's a defective design and there's a consequence of that,
I've heard of that case.
it's done, right? So I mean, A is a good answer. A is a correct answer though, like legally speaking.
A is a correct. A is a possibility.
Right.
I wouldn't argue with that, but this is just economic loss. You can't sue for economic loss only under strict liability. You have to have actual damage.
Were you looking at 23?
23.
The steel plates on the.
23. We're talking about a steel grain storage tank from that Jerk used in Philo's feed processing plant.
But what do you think?
After about 10
Well, the
years,
correct answer, according to the answer key, is C.
It's C. For 23.
Yeah.
No, it's D according to
It's
the
D.
Oh, D. Sorry.
Okay, I was gonna say no.
Oh,
it's
sorry.
definitely D.
Yeah, it's
D.
D.
cannot recover for economic loss only.
Under strict liability, you have to have damage.
Okay.
Okay, anything else I can
Okay, yeah.
Okay, now
That makes D even the better answer.
Okay, you actually did see me going, what are you talking about?
Sorry.
Now I know.
I thought that you were saying C was the correct answer. Sorry.
Yeah, I thought that it said C was the correct answer too when I read it.
No, that makes sense. So yeah.
That you don't have enough facts to know whether
Yeah.
they've been.
Right, that's what I was saying, like how can C be okay? But
I mean,
D,
it could be C, but I don't know.
because if D is that way, then you can't prove A, so D's even a better answer than A. Okay.
Yeah, I mean, A's not a bad answer.
Okay.
You know, I can't argue with you on that. I wouldn't say that that's a non-starter.
D's even a
It's
better
not the
answer.
best answer. D's the best answer in this case. You have to have some damage. It's not economics only.
Economic loss would be like,
That's
we can't
the-
use the grain silo anymore, or what's the?
Yeah, the grain's screwed up now, or
Yeah, you have to have something.
you know, or you couldn't feed your cows and the cow died or something.
Something, yes, you have to have, you can't just have economic
Okay.
It's the Ford case.
See, 26 is too long to argue about. What'd you get on 26?
That's right.
Did you really?
The only other one that I didn't quite understand was 32.
32. I missed that one.
About strict liability for a seizure while driving a car.
Oh,
That wasn't foreseeable, but I know like foreseeability is an element of strict liability, but I thought in order for strict liability, there has to be an ultra hazardous activity, a wild animal, or design defects. Aren't those three parts of strict liability? So then, I mean, driving a car wouldn't be an ultra hazardous activity.
right. But yeah, that's a poorly yeah. I mean, I do the same thing. I put B, but I think that the strict A is a really good statement of the law. It's just not quite answering the question very well because I guess it is. It's answering the
But
question.
even if the seizure was foreseeable, it still doesn't make it an ultra hazardous activity. It's still just negligence. I mean, we have people who have diabetic comas all the time and get into car accidents, and it's still just negligence, even when they knew that they had issues with diabetes.
Yeah, I'll go with that. I mean, I guess B at the time. I'm not really sure why.
Which should you think was the right answer?
I said
think
B.
A.
I said B, but is it?
Because I thought in order for strict liability, it either has to be a design defect, an ultra hazardous activity, or a wild animal.
But see, she's on notice that she has.
How else do you get strict liability in a car accident case?
Well,
Because he had a seizure in the past and was cleared?
If it was foreseeable.
I mean,
well, I mean, you can sue for damages in strict liability. It doesn't have to be a wild animal or, although I would argue that this might be an abnormally dangerous activity if you know you're driving and you're prone to seizures.
I think I remember a case
I think that would be kind of a problem.
that in towards.
but he got his license back. So, I mean,
Well,
Right.
but if it's foreseeable, that's the problem. Because then it doesn't matter how many precautions you take. Right? That's the whole point of strict liability.
yes.
What about 38? Are we still arguing this?
No, I mean,
I mean, it's funny because I kind of like A. You know, just so you know, I mean, it's not just.
well, of course you like A. You chose that for the answer.
Well, I'm going to give you guys the list of the cases, for Christ's sake. You can read it for yourself. I mean,
What about 38?
oh yeah, I remember this case. It's called Hammondtree versus Jenner. That's actually a cool case. California case. But I actually have heard people use this here.
So do people just sue on a negligence theory because it's easier than a strict liability one, like for those kinds of cases? Because we have two in our firm right now with somebody who went into a diabetic coma while driving, and it was their second or third accident from a diabetic attack, and it's just a negligence claim. It's not strict liability or anything. They don't bring it under that, but.
Well, I think I would bring it, well, I mean, personally.
I mean, they also tried to bring punitive damages, saying that it's a bad thing, and they always get struck down on demurs. But that's why I answered the way that I answered, because I was like, it's not ultra hazardous. Hazardous regardless.
That's pretty hazardous. I mean, to be honest you're driving knowing that.
But based on the facts, it wasn't ultra hazardous. No, because she was cleared. She didn't know.
Yeah, I mean, the DMV gave you back your license.
Yeah, and she had
you're clear.
seizures since that point. You know, it wasn't foreseeable. So
I mean, yeah, it wasn't foreseeable, but I just didn't realize that would qualify as an ultra hazardous activity.
driving around in seizures foreseeable.
Oh, yeah.
I mean, if shooting a gun isn't an ultra hazardous activity, how is driving around in a car an ultra hazardous activity?
Well, driving a car knowing you may have a seizure anytime.
If it was
I mean,
concealed.
driving a car while drunk isn't an ultra hazardous activity,
Just you people do it.
even though it should be.
That's not, I mean, B's not even a good answer though, to be honest with you, really read it. Denny, because driving a car is not an ultra hazardous activity. That's true. What's the problem with that though? Think about it for a minute. That's true. I would say B's true. I mean, driving a car is not in and of itself an ultra hazardous activity.
You're not just driving a car, driving a car while being prone to seizures.
Correct.
But he's not prone to seizures, he had one.
He said. Is that what it said?
Yes!
That's what it said.
He had one and the DMV gave him his license back.
One like 10 years ago.
Whether it's for
He was like really low on sugar, man.
I don't know if it's foreseeable. I think he's under strict liability as well.
All right, let's go to 38. This is a question
I mean,
quasi-contract.
I would rather, given my druthers, if I can prove ultra hazardous activity, I'm gonna go there for sure. It's much easier to prove, I think.
I think it'd be hard to prove, but it'd be easy to allege the elements of.
Like, how do you prove that? That you was just like, you knew you could have us, didn't you? You knew!
Well, it's
No.
very dangerous.
Yeah, but my doctor said I'm good, the DMV said I'm good. What more do you want from me?
Therefore, no, I didn't know. Exactly.
I can see the motion coming back at you. Now you like the DMV? Uh-huh. Yeah, it doesn't work for me. Let's be forward. Okay. Yeah, I'll give you a little second. That's actually you guys should know that case though. It's actually good law. I've heard attorneys use that case. It's cool stuff. Yeah. Did you have one more? Or
Yes.
another?
38 is a question in quasi-contract. So basically in this case, guy buys a horse comes lame, he refuses to accept the horse, a third party takes in the horse and starts sending buyer bills. Buyer just turns them back saying, no, not my horse, not my horse, not my horse. I do think there's an implied impact contract here.
Yeah, me too.
No way.
It's not
That's a business case too.
He returned the horse.
No, he didn't return it to the. He just dropped it off at a third party's farm.
His job was, he didn't just drop it off to a third party's farm and expect not to pay for the third
The
party.
driver is the agent of the seller.
There's no driver
There's
here.
no
Yeah.
38.
Yeah. He purchased it from Holiday.
Okay.
When it got brought to him, he ordered it to go back to Holiday. Holiday refused to accept the horse, so the driver bought it to some random ass
That
farm.
makes sense.
Okay.
Yeah.
So how are you responsible for
You're not, because the
The-
driver's the one that dropped
the
it off.
driver not returning it back to the seller and bringing? That's like somebody selling you a car. They deliver the car to you through a third party. You say, I don't want the car. It's broken, clearly. And so they bring it back to the seller. And then they bring that car to an impound lot. And now you're stuck with the impound fees. Because some third party driver dropped it off.
I understand what you're saying.
Yeah.
I mean, I wouldn't expect to be
I
on the
think-
hook for that.
I think you need to bring your suit. You can't just say, no,
But it's a good. You can refuse acceptance of a good if it isn't it's perfect tender rule.
Driver should have taken it back to holidays.
So you can refuse acceptance if it's not perfect. And if the horse is lame, then it's not perfect tender. That's like you getting rotten produce and sending it back.
okay, well, and,
I don't know. I think it's safe. I mean, again,
okay.
they really don't have a contract.
Yeah, that makes sense.
What are the rules of quasi-contract? Quasi-contract
This is where you don't actually have a contract, but you do something in furtherance of a thought that you had a contract.
Right. Now, in that case, if it was no driver and the buyer just drops it off to someone else's farm,
It could be
then
different.
so that's the fact pattern I had in my head.
It is for me too. That he was responsible for the horse being at that third party. In my head, I believe that the buyer was responsible for the horse being at that farm.
You know, it's Holiday just told him I'm not going to take it, so the driver took it upon himself to drop it off at the farm.
Fair
Yeah.
enough. Fair enough.
That's another cool case, though.
Should be blaming the driver.
That one's called Bailey versus West. Again, another big case.
So the only question that I had, and I don't even know, I don't remember really learning it, and I'm not arguing that I got it wrong, but what's the doctrine of economic loss in question 36? Because reading that, I'm like, I don't know what that doctrine is, and I don't ever remember reading about it.
Economic loss?
Well, the doctrine of economic loss? What is
You do
it?
that in torts, for sure, if nothing else.
36.
Was that the answer?
Well, no, it says that they dismissed the misrepresentation claim based on the doctrine of economic loss, but I don't know what the doctrine of economic loss is.
Well, if you want to sue, it's what case is that? It's a car case. You learn it in torts class that sometimes you just have to have you can't sue for economic loss only.
So that's just what it is
Yeah,
that you
it's just
can't
a fancy
sue
word
just
for
for
it.
economic damages?
Yeah, it's just a fancy way of saying it.
What would you possibly have guessed on this?
36.
mean,
I said D.
I would think it would be. You'd have to have a tort, otherwise you would be in insane trouble with that case. Alltech Telecom Inc. versus Emily Corp. You can read that case. That's a good one. These are pretty good cases.
But it's not. Oh,
So these are real MBs.
Hmm?
These are real MBs. Are they? Well, I'm asking, like, where'd you get them? Did you invite them?
I think I wrote them.
Oh, okay.
well, they're based off of note cases.
they're all
The
note
majority of
cases.
them.
Almost all of them are note cases.
I just don't ever remember reading like doctrine of economic loss. That's why I was.
It's just a fancy way.
So
of saying
whenever they bring like misrepresentation in the contract, that is a separate tort in and of itself from the contract.
No. Well, no. It'll.
misrep, I'm not 100% sure, to be honest with you. Fraud is, that I'm sure of.
What's the difference between misrepresentation and fraud?
Nothing.
Because fraud has scienter and misrep might not.
So if
There's
it's
a difference.
intentional misrepresentation,
Exactly.
then you can separate it
No, no,
from
no.
the
Intentional
contract.
misrep is
Well,
what
we should check on
in
that to make
California,
sure, but
what we
you
call
have to have some
fraud,
scienter.
legally, is called intentional
Intentional
misrepresentation
misrepresentation.
from a legal perspective.
So if it's intentional misrepresentation, you could separate it from the contract and sue for intentional misrepresentation as an independent tort,
Yes.
thereby giving you punitive damages and allowing you to throw out a case by saying that it's purely economic.
Yeah, that I'm pretty sure in California is the rule, yeah.
Okay.
Because you have to have some, you have to have bad intent. It's not just it's not just a, an innocent misrepresentation or something. You can't get punitives for that. There's no way, right? I mean, that's just kind of common sense.
Well, that's why I was confused with the first the 27 question that I asked, because I just didn't see. I saw the intentional misrepresentation, but I thought that when he sued for deceit and breach of the contract, I thought that it was like fraud in the inducement of the contract. Therefore, it was all one claim that they're suing under, rather than a tort claim and a contract claim.
Because the contract, what you're going to do is you're going to sue on the contract, because obviously there's some breach, right?
Mhm.
But then what you're going to do to get the punitive damages is
tack on a
find the
tort claim.
underlying tort. And the reason, it's funny that you should mention that too, because the bar loves that. You will get at least one or two MBEs.
So if it's an intentional misrepresentation, you can sue for the underlying tort of
Yeah, but
fraud.
because there has to be an element of intent and scienter. Otherwise, it doesn't rise to the level of fraud.
Because then if it's just just a negligent misrepresentation,
Yeah, that's what it is.
then that's a unilateral or it's a mutual mistake then, right?
It's
Just think,
Okay.
when you're pleading
Well,
breach of
it's closer, yeah,
contract, right?
It's much closer.
You have to also plead a separate cause of action for fraud in order to get punitive damages in your complaint. So literally in your complaint, you have to have two causes of action. You have to have for breach of contract and for fraud, or else you can't get punitives at the end.
Well, I didn't think
If you only bring the breach of contract and then say in here that, oh, there's been fraud and blah, blah, insufficient. You have to plead breach of contract and fraud to get punitive damage.
Okay.
That's all that means.
I knew that you had to plead fraud, like if there was a misrepresentation or something like that, but I didn't know that even in a fraudulent contract, you could get punitive damages. I just
You
thought.
can't, you have to plead both.
You have to plead tort post fraud.
Two causes of action.
You can't plead a contract, you have to plead a tort.
Okay.
That's the whole point.
You just have to plead both.
Okay, I got it. I just didn't know
Just
that.
when you're in practice, plead both.
Okay, well, that sounds pretty good. Yeah.
And then the doctrine of economic loss just says you cannot only sue for economic loss. You have to have some kind of like personal, it's non-economic loss, like pain and suffering or
Yes.
something like that.
Yeah, you can't just sue for economic loss. Right.
You want me
Yeah,
to tuck it in
actual
there?
damages.
You want the essays
Oh, no,
tucked in
here.
there?
There's another
I'll hear you guys.
thing for it.
So anyway, just so you know, this was my, I'll go ahead and let you guys look at this, if you want to. Actually, we'll just go through it pretty quick. Here's the question. Let me just go ahead and give you my, this is actually
Oh,
an
yeah,
answer that I.
we should
that I-
see his, can you hand back the essays?
Yeah, I mean, you should actually, I'll let you guys take a look at this and then I'll go through it. just
Sorry.
real quick.
Thank you, Vincent.
This is actually like a model answer that I wrote. Okay, like this would have been like, you know, very Cadillac-y. Okay, anyway, so you have the fact pattern. So what I did was, okay, the answer was number 1, Java code versus plantation, right? And of course, it's UCC, right? So that was my first heading. I went ahead and did that. Merchants as well. So that's fine. So we have two UCCers. Valid contract. Again, you want to go into it. Just kind of mention what it is. Those kind of things. You know, this is just the way I would have written it. But that's pretty good. Defenses to formation. Statute of frauds, of course. I always use that because that's tells the reader that I'm done, that I do have a contract, but that's my last issue, and then I'm moving on. Now, the next issue that I picked up on was anticipatory repudiation. Again, the time has not run. I mean, it's theoretical, but anticipatory repudiation, if it helps, okay, some students it does, some it doesn't, but I always just think of it as a remedy. I always say, okay, I got a contract. Do I really have to wait 2 more weeks? I mean, all I'm going to do is suffer more damage. That's crazy, right? So to me, anticipatory repudiation, the reason it's good, the reason we have it, you know, is because it really, in my mind, it's a remedy. And you know, it's not, it's a doctrine of contract.
Yeah, I saw it, but I was like, I don't know where to fit it in.
So
Yeah, I threw it under like a modification, like one party requested a modification.
yeah,
That
I mean,
was stupid, but.
yeah, I thought that's not bad. You know, again, I could live with that. You know what I'm saying? But again, this is just an answer that I wrote.
Mm.
Just okay, I took my own test, and so I wrote my own answer. I did not take an hour, by the way. I took my time. So, but anyways, well, I'll let you see what I would have done. Specific performance was my next issue. That's a possibility if I can make the claim that they're unique. I don't know, maybe. It's kind of a coin toss on this one, but you know, either way it shows would have been fine. Preliminary injunction, right? Okay, that would have been my next issue. I think that's fairly important. Temporary restraining order, kind of a long shot again, but you know, I don't think they would do that in this case.
Under call 1?
What'd you have?
Yeah,
What'd you have
A
under
TRO?
I just threw it in there
Oh, wow, okay.
just to make sure.
I thought that was like.
I figured it was already sold. What are you going to get a TRO on?
Yeah, that was my whole point. But
Oh, okay. I was like, wait.
So what'd you go through under call 1 again? What were those,
yeah, these are all call 1.
what were the call 1 defenses again?
Okay, here we go.
Because I just did a possibility and impracticality, and he had several others that were good.
Okay, UCC, valid contract, defense of formation, statute of frauds. That was the one. Anticipatory repudiation and specific performance. In a case like this, I think was most likely you were going to get. Preliminary injunction, and then I just threw in temporary restraining order. And the reason I throw stuff like that in there, though, is just I didn't forget it. It's just it's really not available here. And then the defenses, because you're talking about equity, unclean hands, estoppel, and latches are the three that I just kind of mentioned. Okay, again, equity goes with equity. So you gotta remember that, right? So if you have an equitable, if you want an injunction, the impossibility is not a defense to that. It's not. You have to have an equitable.
Well, but I thought that, okay, sure, yeah. No.
Yeah, it did.
Interesting.
I mean, if you did if you did some of the other ones, that's fine. But
The calls just kind of confused me. So like because it seemed like to me call 1 and call 3 were kind of the same.
Right, until
I started to think about it, I was like, well, call 1's kind of asking the equity side, whereas call 3 is asking for the legal side. But
yeah, that's what I mean, 3 is definitely the.
I thought call 1 was just asking for enforcement of the contract, it was asking for performance. And then I got impossibility and practicality in a very weird way. I just literally said that an impossible performance, if it's impossible, how can you get specific performance? Think about it literally. You can. You know what I mean? From a literal perspective, impossibility must be a defense to specific performance.
yeah, but impossibility is a defense to breach, and at that point they'd already breached.
How can you specifically enforce something that is impossible to do? To me,
I see what you're saying.
it's goofy.
Well, that's a kind of real world. It's like, whoa, that makes way too much common sense. I'm not sure about that. But try to keep. I mean, again,
I failed. I don't know why.
But try to keep
Since
equity.
these are available, it's not possible.
So you didn't go into compensatory damages? As far as expectation, consequential, and I don't have the questions in front of me. That's why I'm I'm trying to remember the calls. So
No, I didn't go into it for the first one. I felt that was really they were looking for some kind of a specific performance issue, some kind of. It was all injunctive relief, which is what he did.
is that because they're trying to enforce the terms of the contract, therefore they want the equitable things to make the contract go forward, they don't want damages?
They want the contract to go forward. They're not interested in damages.
So you just wanted equity in all of these?
Well, the third one, I think.
Well, the third one is if they elect to forego enforcement and sue for damages, then what? Defenses, but it didn't actually ask what remedies under it, it's just what defenses can they raise. And that's where I brought up the legal defenses of impossibility, practicability, force majeure, and all that other stuff. But okay, I guess I must have skipped over to enforce the terms. I know.
I mean,
I probably could have finished it if I,
go
through all those
expectation, consequential, and incidental.
Okay, but this is what I told you on the scale of difficulty. I put this at an 8.5.
Okay.
This is a hard question. I mean, I saw a lot of wrestling, which is what I wanted to see. Again, I take it into consideration that, I do not expect you to write this. There's no way. If you write this, there's that black robe in there. I'm gonna get that for you, put it on you. We're gonna take you down to not the Supreme Court, the California Court. We'll take you down there. You can be a judge. You could write this paper today. But you guys, did a pretty good job. You were wrestling with it. That's what I really want to see more than anything else at this stage. That you kind of not quite. I can't say you guys really attacked it, but you don't have to at this point. That's but it was good. I mean, I saw some wrestling. I saw some thinking. A lot of different stuff. This is like a real pinball question. Everything bangs off it, everything else. Got to be able to keep it straight. I want to give you a little pressure now. So if you felt that, if you looked at this and said, I'm going to kill him, fine. I probably deserve it at this point. It's a really long question. I'm sure you didn't appreciate it. But you will someday. And I wanted you to feel a little heat. You're in the 4th year now. So imagine that times 100. Unless you're ready to rock and roll, and you will be, right? So, again, but 8.5 is like, this is the average bar question. You know what I'm saying? Although this one's, again, a little on the hard side. I mean, this one, the good news about a question like this, you see this one, you now know 25% of the room fail. I guarantee it on this question. They will fail on this question. It doesn't even matter what else they do, because they're going to take a 55 or a 50. That wouldn't shock me. So you do that, and you mess up your PT, and you're gone. You're gone. It doesn't even matter what you do on the other questions.
I mean, it would have been better if, I had some level of reading comprehension and
Well,
didn't go through my competitive curriculum.
but we're going to work on that. We're going to work on, you're going to have everything down. You're going to have everything from square one. You see what I'm saying? Okay, again, you're going to read the question. You're going to read it twice if you have to. That's actually a do not go off, until you understand the question. Don't do that. You're going to be sorry. If you try to save time that way, oh man, you're going to get what you get. One of them will trip you up. One of them will. But we don't do that. Okay, but again, it's more like just step by step by step by step. And then all you have to do is figure out how you're going to do it. Then practice it over and over until you're so sick of it that you just can't wait to get it over with. You will pass. That's the student that passes. Period. That's it. The student that walks in and thinks they're going to, Cardozo the place, that's the student that fails. Doesn't work that way. Okay, so now that we've read it, okay. Anticipatory repudiation, again, the time hasn't run yet. So again, it's just that simple. Specific performance, I think that would be what you would want, considering that these are they really unique? The answer is, I don't know, but how much does market, I don't know. It's funny because I've actually shown this to other law professors and stuff. And it's like 50-50. It's like 50 think the court might do it. 50 think the court wouldn't do it.
They're as unique as carrots.
They're as unique as carrots. That would be a good way to put it. To me, I think that for the industry. And the funny part is I actually, just so you know, this is not a case. I researched this. And now this is actually really the way this stuff works. If you can believe that.
I didn't give them the TRO or anything, because they could still go get it from the broker.
That's just me being.
I gave them the TRO against the broker.
I probably will. Okay, so anyways, temporary restraining order.
Also, the plantation is really just shooting itself in the foot here. If you work out the map, it looks like, because under the rules of cover, plantation is now going to be liable for $1,000 per ton. It can be liable for which puts them at a lower amount that they would make. So they're selling it for $750 or $1,750, right?
Yeah.
So they're still liable to the plaintiff at $1,000. So they're actually making less at the end of the day once they get sued and plaintiff gets their cover. Plantation's actually making less money. So I'm going to go ahead and let plantation screw itself over. Like, I'm not going to step in, right?
Okay, I can see that. That's possible.
Is that ethical though?
Why does that be? How would that be?
BIDNESS.
BID.
Bidness. So you need to know. All's fair in love and business, as we say, right? Okay, so JC versus broker. I think a preliminary injunction would probably be pretty good. I don't know, maybe not, but temporary restraining order. I don't know, but again, I'd bring them.
Well, if you're going to grant the preliminary, you should grant the TRO. I mean,
or not. Again, it's 50-50 on this question. It doesn't really matter which one you choose. Here's a good one though, which I also wanted to show you, which is it's something you don't learn a lot, which is in class or anything. The All Writs Act, which actually is fairly important, which is actually a piece of law that's actually good to know. When the court orders a preliminary injunction, they are also able to issue as many writs as they need to issue to make it happen. So you might want to throw that in. It's worth a point or two. You can read my little description of it here.
So you're saying if they rule the TRO against either the broker or the plantation, they can just writ the other one and just enforce it on both? Because don't writs go up? Writs usually enforce a public entity, right? I thought a writ goes up to tell somebody lower to do something.
Well, a writ is an order that tells anybody to do something.
Okay.
I mean, there's different writs, but a writ is just something that says, hey, you do this. That's literally what the meaning of it is. There's different writs though, interlocutory, going, appellate.
Right.
But anyways, let me just read this to you so you know. It's good to know.
Yeah, I didn't know heard
When you get in real life, it's good to know. You can get these other additional writs. In the event JC got a preliminary injunction or TRO against PL, plantation, the court is empowered to issue all writs necessary to enforce the preliminary injunction, even against a third party such as broker. But watch that though, because what if they did nothing wrong at all? So you got to remember that case we had. So you got to make sure they're in, did something. They participated to some degree and could have some liability. However, this power is considered extraordinary in nature. That's true, they don't usually do it, but they do. And again, as broker is an innocent party without liability, it is unlikely the court would issue such a writ against broker. So again, but it's good to know. And that's the way it works in the real world. So, just so you know. So you had a little tidbit there too, which is good stuff. Damages, it's hard to say with broker, they're not really in privity with the Java company, so that's a problem. Number 3, damages, okay, probably no punitives in this case. Compensatory is a possibility. Contract price, all that stuff. So that's pretty good. Incidentals.
But would you bring up the actual damages if all the call asks for is what defenses could they raise?
Well, you have to go, on the bar, you have to go through the damages.
So still
whenever you
goes,
see that, you have to go through the damages. You just do.
okay.
Don't just start with defenses. That's, again.
all that I did was cover, but I was pretty much running out of time at that point.
So I just put them in
But I
the
just
call.
I mean, hopefully,
Instead of call very hard.
I was kind of hoping all 3 of you would run out of time. So
I did.
know what it feels like.
Both business associations only took me 45 minutes.
No.
So I went back and finished up this one.
I have to have a talk with someone.
Otherwise, call 3, you would have just seen.
Yeah,
Call 3, you would have just seen head notes and rules, because that's how I left it. And I was like, by the time I'll go back.
I stopped doing that a long time ago. The racehorse I put last, because I know it's probably a joke, but I'm going to get what I get. So it's a racehorse, I put it last. Spend my whole hour, and the dominoes fall where they may.
It's like, didn't you guys ever see that Star Trek when Kirk can't win? You ever saw that one? Oh, it's
From Star Wars, not Star Trek.
It's called something Maru.
Kobayashi Maru.
Kobayashi Maru. Thank you.
In no-win situation.
And it's they basically you have to take a computer simulation that you lose. No matter what you do, your ship blows up. And the only person that ever passed that was Captain Kirk. The reason why was because he went in and he rewired it when nobody was looking.
He cheated.
So he cheated.
Yeah. That was in
So this was your Kobayashi Maru case. If you guys really could get through this, I was like, whoa, yeah, this is okay stuff. Hard question. Just to finish that up real quick, compensatory, consequential, lost profits, and went into restitution, mitigation, defenses, unconscionability, and practicability, which I thought were the 2 you probably best move, but hard to say. Okay, you want to take a peek at this? Well, I think,
No, I should have gone through all the damages at the end and
Well, again, I'm trying to get you to do as much.
right equitable defenses at the beginning. So I would have gotten a lot higher score.
Yeah, for sure. I mean, it was definitely a racehorse. I wanted to see Sweat. You know, Sweat got you some pretty good, points for this question. A lot of writing. You hear the right a lot. And again, it was kind of like, you gotta learn, and plus, I'm telling you guys, the trend is, and I heard someone else say this about even the last part, the trend is for racehorses. They want more. More is the way to go. Just is. You're bulletproofing, I hate that term, but, because it's not true. Nothing ever bulletproofs you. You get shot, you get shot. But anyways, but bulletproofing, that's the thing, is every time you leave off something that's not there, that's it. You lose points. You can't regain them. Every time you write something that's, not there and it's not there, it's just you lose time. So you've got to kind of figure out how to do that. You've got to figure out that your style has to rely on you being able to write more and not less. The idea that you're going to write less is not going to work. It's not going to happen, right? You can't do that. Got to do more. Okay, that's the way to go. Got to go ahead and kind of, insulate yourself, so to speak. Yeah. Okay, any other questions about the test? No? Okay, good. Well, let's see. What time is it? So it's 7.
Quick break?
Yeah, why don't we just take our break now? And we'll
Alright.
take it.
Kobayashi
Now, next time you find me, you'll see Kobayashi was Anne Marie entered into a contract. And you'll go, uh-oh.
F my life. Set the racehorse for last.
Not a bad idea. See, that's what I would do too. I would do the racehorse last.
Would you?
Oh yeah, because I'm going to beat up and get as many points as I can. Chances are is I'm going to run out of points anyways.
Right.
So what the hell?
Right, exactly.
I have nothing to lose by doing that.
Well, because it also falls into your strategy of making sure you get 70 to 80 on every test.
Yeah.
Don't go out and shoot for the 85 on the racehorse.
Yeah.
And I'm totally liable to overwriting and screwing up my little jam. That is possible for me.
Or misreading names.
But that's the way to do it.
Missing a second gunshot.
Right?
All that stuff happens.
Just take 15 minutes, okay? 15, all right? Don't take any longer. Yes.
I asked Cole.
She was.
It's cool, chill.
I'm sure it is. But
I couldn't deal with secrets, like an actual teacher.
Commissioner Reed was actually a good teacher.
she was.
She was a really good teacher.
Minus the fact that I couldn't use my computer.
Oh, right. That was that was the one that was like really like, it actually hurt us because we were having to study at the end.
I mean, I wrote notes, but yeah, and then she didn't send us a PowerPoint. So like,
Right.
the fuck am I supposed to do?
You just wing it. The thing about that test is that there's no reason why anybody should fail that test, other than that they couldn't find the time to like take 2 days to review for it.
I studied a half hour before the night before.
But imagine if anybody spends like 2 days.
Sure, I got the lowest score out of the 3 of us.
But
But that's multi-states in general.
Let's
be honest.
Because you blow through them.
I only got 1 less than you.
Well, if you didn't blow through them.
So, and business organizations is just flat out wrong. Indemnification is not indemnification. We literally spent like 15 minutes on ratification. Hit someone with a ball.
I thought some of them were like kind of new to me too. I'm not sure if I just read as closely, but
In business organization?
Yeah.
I didn't look at them like closely because I was like,
Well,
oh,
first
if I
time-
got them wrong, it's because I didn't know them. But then you started pointing out like how blatantly wrong they were, and I'm like, oh.
a couple of them were like, holy shit,
You know, this business organization was the only one that he didn't look at because I was like, I know I didn't know anything in business organization, so I was like, I probably just got them wrong. Indemnification, my ass.
Can we go home now?
You have to consent to be sued, unless it's an administrative function and not a judicial function.
Okay.
Okay, we're done. Just same with Congress people.
See, an administrative function. You're talking about administrative function, that's just of the court though, right?
Well, no, the judge. So like hiring and firing a clerk, that's administrative, not judicial. Apparently dragging in the coffee guy is not.
I didn't read those little cases. So I don't know what the fuck you're talking
You should read some of them because they're hilarious. Like one of them, the judge like it's a bad cup of coffee, drags the barista into the courtroom, says, "I will destroy your livelihood. Like, how dare you do this? It can never happen again." And he sued the judge because like the judge put him in jail and stuff like that too.
Wow.
And the court's like, he was acting in his judicial capacity. He's immune. And I'm like, no. He's not.
He is acting within just.
And then there's another one where somebody honks at the judge in their car and like cuts him off. So he puts a little red light on his car, tries to pull him over, but the guy didn't pull over because he's like, anybody can have one of those little red lights in their car. He's like, I'm not just gonna pull over. So then the judge sends his deputy to the guy's house to give him a summons to appear in court, holds him in contempt, sends him to jail. The court's like, okay, so pulling him over was not part of your judicial capacity. However, dragging him in for the special hearing and holding him in contempt, that is. And you're immune.
You're immune for abuse.
No! Of course, they all get, like, unbenched, but
You're immune for your abuse. You could just, rape somebody in court and you're immune.
your punishment is I get to rape you. I'm immune.
And I did not consent to.
And, like, one of them is, like, a judge taking a bribe is part of his judicial, like, conduct, so he's immune. But the person who bribed him is not sharing that immunity.
You bribed that ticket, but you're going down.
Yes. And then for congressmen are immune as long as it's within their functions as like a legislature. Their aides are immune as long as it's within the confines of
But what could they do wrong in the confines of their?
get bribed.
Okay.
I mean the big protections are like
You see, we gotta get.
non-constitutional or like laws and stuff like that. Like you can't sue them civilly for that.
That's actually understandable,
But only the president is immune, but not
the
his
bribes.
aides.
But the bribes should absolutely.
No, if you're your bribe is not part of your job.
Right.
Why would you be a congressman?
Yeah, I know.
No,
It's
it's true,
bribes.
and it actually hurts our respect for our government.
Yeah. Like,
The court needs to back off on that.
granted, I don't know what you would sue someone civilly for. I mean, unless at least a congressman, a judge, I can understand. Like one of them was like a judge and a prosecutor worked in concert with each other to get a person put in jail, and they're like, nope, that's part of their judicial and prosecutorial function, so they're immune. And I'm like, no, no,
You're retarded. That's bullshit. That's what that is.
yeah.
Fucked up. Okay, we were told 15 minutes. Like
20 minutes ago.
22 minutes ago.
It's like 5 minutes late so far. It's like,
You can't say anything. You were late to class.
Yeah.
so they can. One time in like 4 years.
Bullshit. You're like 1 minute late every single day.
I just don't want to be here anymore.
No.
You're not Beto, at least.
I feel the same way, man. Yeah. It's so hard to like.
I feel like that hour of talking, we could just do drills, man. Let's drill some rule statements. Let's do something.
Yeah. Well, we could actually have value in this class.
Yeah.
And we don't have any. You know what I think.
That's true.
Oh, let's bust through these and get out of here. What do you say? Bust through these cases.
Yeah, let's do it. Let's bust it out.
Bust it out. I'll get the door.
States are immune. End of story.
Unless
The government is immune. End of story. Judges are immune. And just prosecutors are immune, and legislatures are immune.
Who would like this list of cases? You are more than welcome to look up.
He's probably the one that's gonna look him up if anybody does. He's a good boy like that.
Again, if I see this online, I'm gonna know where it came from, and I will hunt you down.
I have absolutely nowhere to post them online, and I'm not friends with anybody in this law school except Will. So, I mean, no one's gonna see anything.
Going.
I can send you the
Yeah,
picture.
sure, you said it.
Yeah, I'll send you the picture.
Then we won't.
Saying you have a picture. It's really an idle thread. But it looks good. It looks very dramatic.
Well, that's next year students don't read the cases ahead of time and get all the answers straight.
Well, you know what?
There are note cases. I was reading through there, I'm like, oh, I remember this note case, but I don't remember the answer.
Yeah, they're just note cases.
Yes.
So,
Yeah, those are hard for me to remember.
common law is the same way. When you took your common law.
There's
like
300 of them. I
Eyes glaze over the citation.
Yeah. I sort of just read the basic principles and I like skim. I skim.
But the note cases are really good.
They're funny.
They're kind of good.
But they make me hate the government even more.
No, it's a big deal though. Like for example, a bribe should be outside the scope of your duties as a judge.
Just take it for your judge's duties.
You know what I'm saying? Like, and it really hurts. And it seems like a congressman, like, it really hurts the position of a government as authority figures to allow them to not be civilly sued, personally sued for acts like taking bribes or improperly putting somebody in prison. I mean, when they know or should know what they're doing is wrong, and they use their capacity in a position as pure abuse, like in those certain cases where there's pure abuse,
like we're like dragging him the coffee boy to berate him about his shit cup of coffee.
Yeah.
They deserved it.
But it's
And then he should be immune for that? No.
when a judge decides to pull somebody
We're
over,
gonna
then
get a judge to explain that to us.
Again, have Judge Evans bring the coffee boy in the Larson Justice Center and be like, you're going to jail because my coffee is crap.
the thing is, those like judges sit up there and they demand so much respect, and they wonder a lot of times why they don't get it. And it's cases like this, and why people don't respect them. Because they know that they can do whatever they want to them, and so they're like, F you. And it creates that level of hostility towards the court.
They end up on the Supreme Court, apparently.
Apparently. He's got like teeter. I couldn't get on this.
Okay, but on the flip side of tonight's, before we get into these cases, you do understand though that the government cannot be sued every time
Yes.
they want someone to just would do nothing but do lawsuits all day. You understand that, right? The government would.
That's what
It is theorized that the government would stop working if we actually filed any and all lawsuits.
Sure.
Because they would have to take so much of their resources
Oh,
to
yeah.
fight it. So on the other hand, they can't. You can't do that. So on the other hand, you know, abuse is abuse.
Well, I kind of think the government should stay out, and if they get in and they F it all up,
They do.
they gotta be liable for it.
Mm.
Yeah, some of these cases, it pisses me off. I'm like,
Even the first
I
one,
would
you know,
just-
even just the general rule of like a government organization not doing proper inspections. Like very simple, clear cut rule, you know, like public utility doctrine straight up, like, you know, it's not a special relationship. It's, there's no, what's the second one? A special relationship or when the government creates a special duty by promising protection. Those are like the two exceptions to the public duty doctrine. And you know, I just think that, so in this case, OSHA was supposed to do inspections. They didn't do.
we're not reading.
This is the first case. Don't be North Carolina Department of Labor.
Hey, Stubbs, a really interesting case.
Yeah. So,
The cases aren't boring tonight. They're pretty interesting.
No, they're just annoying. Like,
Well,
not
they're
annoying,
very
but they're
frustrating.
infuriating.
after a big fire,
I agree with that.
where people died
A lot of them.
because exits were unmarked, blocked, and inaccessible. there was a review done and 83 citations sent out. There was never any review of these exits by OSHA. OSHA didn't do anything. They had an inadequate fire suppression system as well. People died. And so employees have died. And so employees have brought suit under the Tort Claims Act, and they asserted negligence for not like inspecting or allowing this horrible abuse of code, and they tossed the suit out because under the Tort Claims Act, this case holds, there is no independent consent to be sued. So the exceptions to that independent consent is when there's a special relationship or a special duty, and that is created where the government basically promises something, and that protection is not forthcoming. That doesn't occur here. So basically, there's no special duty or special relationship created, and there's no direct consent to be sued within the Tort Claims Act, and therefore there's no way to get to them. And that's the case.
Okay, well, let me ask you one question, just out of curiosity. So, from a tort viewpoint, though, what was lacking?
What was lacking?
Well, why?
Duty.
We're saying they didn't have a duty,
Right.
Sure.
but they did.
But they did.
Because they assumed the duty by creating OSHA and having rules and saying they're going to inspect it. I mean, I can actually understand this case because.
Well, it's right there on 523. Let me just read it to you real quick. Further, we do not believe the legislature intended to impose a duty upon this agency to each individual worker in North Carolina. The most the legislator intended was that the division prescribe safety standards and secure some reasonable compliance through spot check inspections made as often as practicable. Because the government entity owes no particular duty to any individual claimant, it cannot be held liable for negligence. Absent of duty, there could be no liability. So they just put on a straight negligence track. But is that true?
Not civilly. If you were a business that decided to, like you were an insurance company that decided to do inspections and like this, like in order to get our insurance communities, you probably would create a duty for yourself, I would think, civilly, if you were an independent actor.
Well, let me put it this way. Okay, so we all know what OSHA is.
Sure.
So does OSHA make good suggestions for this, or what do you think? I mean, are they a suggestive agency? That's their only job, is they suggest that businesses.
No, they can shut you down.
Okay, then now we're getting somewhere. So they do have some teeth, right? They do have some enforcement power. Is that true?
Yes.
Why give them that if they have no duty?
Yeah.
That's kind of the
It's kind of because we're crazy. That's why. Because we're crazy.
I'm not arguing with you. I think this case is nonsense.
Yeah.
I mean, I know what they're trying to say. They're saying, well, OSHA can't have a duty to every individual person. But my answer is, why can't they? The government works for us. Who's us? You know what I'm saying? I mean, why are they doing this? And this court makes it sound like, well, OSHA comes in and they make suggestions, and maybe the bosses do it, and maybe they don't. Maybe some people die, but that's nonsense. And what happened?
There's no maybe. They shut you down if you don't do it.
I don't know what they do in North Carolina. Ever that fly across California, to be honest with you. But anyways, it just seems to me that, again, to me, I feel your pain, is what I'm saying. I mean, this is nonsense.
It's nonsense.
And why do it then? What's the point?
Just set of regulations. Just to harass businesses.
Yeah, pretty much. We just go in and tell you everything that's wrong, and we go.
Yeah.
It's no different than the food inspectors.
Well, no, let's just take it to
I
the
mean, if I
next.
get food poisoning, I can't sue the food inspectors for not coming out and inspecting.
Okay, but let me ask you this.
But
question.
you can still sue the company, right?
Well, yeah, you can sue they can sue the company in this one too. I mean, they just want to go after the deep pockets,
Oh.
the deeper pockets.
Wait, so why don't they sue the company here?
I'm sure they did, but the company probably went bankrupt after the
Oh,
fire.
that's highly possible too. But let me ask you a question then. Okay, let me see if we can expand this to our favor. So,
The personal injury suit should give preference to the bankruptcy.
I doubt
But
that.
let me ask you a
No, we
question.
should.
So you mean, in other words, paying taxes is kind of a suggestion? You suggest I pay these taxes because the IRS can't enforce it?
Well, technically they
Idea.
can't.
Like, they
I mean,
go to jail. What's that?
No, you can't go to jail for not paying taxes, can you? Because isn't it basically debtor's prison
Yeah,
No, you can go to jail for paying taxes. It's
for not paying taxes?
Oh, yeah.
yeah, thing is,
I thought that's like debtor's prison.
no.
Not when it's the government.
You're just not paying taxes. I mean, what if you can't
You're
pay
making an
them?
interesting distinction, which is, I mean, if you're, hiding taxes.
I mean, if you're hiding them,
But just
then
not paying them, I think that if you do it for, I think you can. That's the whole thing.
okay.
I'm pretty sure
Yeah,
you
they
can.
got Al Capone for like tax evasion.
Yeah.
But that's tax
Well, that's
evasion.
tax I see the difference.
He's specifically not paying them. Whereas, like, if it's a poor person,
But you've made 100%. You can't pay your 30% or whatever it is. I mean, why not? It's evasion. If you spent it on something else,
Well, but you have a duty to pay tax.
yeah.
So, I mean, how long can you just say, I didn't feel like it?
Well, yeah, and that's evasion. That is
doesn't
evasion.
make a lot of sense. Yeah. I mean, it sort of leads you to another. I see what you're saying.
Well, it's a good
Exactly.
deal,
I
It's
mean,
tax evasion.
you have a duty to pay your contracts too, but you can't go to jail if you don't pay your contracts.
I think that it's
That's
tax
Yeah, because it's not the government, and the government says we're important. That's the only difference.
And you can't sue that.
Yep.
Yeah, exactly.
Just so we're clear,
Today's hate government day.
See, I mean, I can kind of understand the OSHA case only because I think
yeah, but see, then again, but then your argument is that
I
I
think it's-
believe my accountant and that's
That's
that's not
fair.
good
They
defense.
should go after the company.
I'm sure they did.
Well,
Yeah.
then what?
But they
why-
probably are, frankly.
Company went bankrupt.
Well, but I think that personal injury suits get priority in bankruptcy.
Well, plus they probably have insurance, so they can go after the insurer.
Right.
I would think.
But whatever's left.
Yeah.
Would first go. I mean,
Given all the OSHA violations, they were probably in breach of their insurance contract, and insurance denied
because
coverage.
actually, attorneys in the government get paid first. Right.
Yes,
in
they're gonna
bankruptcy.
They're gonna get all their fines for OSHA violations, so OSHA's gonna get paid and not pay out.
Then the PI, but there's probably nothing left after the attorneys in this case and all the fines.
That's true. I mean, that's why they're going after OSHA. I mean, they need a pocket to pay out. I mean, that's kind of obvious. And it goes all the way to the Supreme Court there, so, kind of interesting, huh? But,
But what's
they said
All
no.
right, let's go home.
What's the constitutional question though? Like, is just governmental tort liability in the Constitution? Because I thought the Supreme Court couldn't hear anything if there wasn't a constitutional question or if they didn't have jurisdiction.
Well, this is the Supreme Court of North Carolina.
Oh, I thought when you said it went all the way to the Supreme
No,
Court.
no, I mean the North Carolina.
Oh, okay.
No, this is the North.
Because I know some of these are Supreme Court cases, so
Yeah.
that's why I'm like, I don't see the constitutional issue. Okay.
No, that. Well, I mean, well, it would be 111th Amendment. That's all about immunities and stuff. But so there are constitutional, requirements, but I mean, I think they'd be able to hear the case if they consented to it. But yeah, they could hear if they consented to it, but they have to consent.
I mean, the only part that makes me understand this case is that, I mean, there are so many businesses and they say it somewhere in there, that there's so many businesses that fall under OSHA's protection that it'd be impossible for them to constantly be able to go and inspect every single.
Well, it should fall on the
Facility.
business. It should set up a duty level for the business.
Yeah.
Right.
And the business should be liable for this. And, yeah.
Yeah, I mean, I see the argument. I mean,
It shouldn't go to the
everywhere
inspector.
can't have a suit against OSHA.
Yeah.
It's not feasible.
Possible, right? But on the other hand, I just think that I just think they.
Well, they can't go in and make sure they shut everyone down and it's slightly out of code. Because then everybody will be shut down. I mean, everybody's slightly out of code will be shut down immediately. There wouldn't be any time for, you know what I'm saying? So if you're out of code and they don't come in and shut you down immediately, does that mean that OSHA can be sued? Like, if this would be the other way.
Right.
You know what I mean? So
Yeah, for sure.
OSHA would be shut people down left and right for any handlebar out of, that's too high or, You know what I mean?
Which they can't do too.
Yeah,
So,
that'd be that'd be.
but on the other hand, I mean, but it's hard to imagine why. But we have a case where there's so many violations. I mean, I think that.
I think this one was just the
partly
egregiousness of
This
everything.
is really bad. Like, I mean, everyone agrees with me. This is bad. I mean, here you are. They're literally going to work in a death trap, as far as we can tell. This is really bad. And yet, basically, we have a situation where probably everything that everyone just said for the last 10 minutes or so is probably true. I mean, there probably is what's left. If there is any meat to pick off the carcass, you're down to the vultures at this point. And so who ends that out of luck?
The injured people.
Can you believe that? And that's just wrong. You know what I'm saying? That's not how, I don't know, and there'd be a lot of different situations, but that's not how OSHA should work. OSHA is a safety agency, right? There's actually a.
Well, yes, but they're not.
No.
They're an inspection
Yeah, what are
agency.
they then?
Well, they're to set a duty for the business to follow, and if the business isn't following that, then the business should be sued.
Okay, or do you think that under these circumstances, maybe OSHA should have shut them down?
Sure.
Well, they would have had they inspected them in
Yeah.
11 years.
Oh, so you mean they actually hadn't even seen them?
No.
Now we're getting somewhere. You see what I'm saying? This case is just, come on.
There's just a lot of bad facts in this case. But even in, as one of the no cases, and I can't remember what it is, they said that where OSHA had gone in and actually told them that it was okay to lock doors for flies, and then there was a fire or something like that, so they couldn't get out. They said OSHA's not responsible because the inspector didn't have the knowledge to see the danger in that. And they didn't assume that responsibility. And I feel like if safety OSHA is telling you that it's okay to lock a door, and then there's a fire, and because of that locked door, they can't get out because OSHA said it's okay to lock the door.
It's just advisory, man.
OSHA has assumed that responsibility.
No, it's just advisory, man.
I know. But the court is just saying,
Dude,
Well, okay.
respect your government.
I'll tell you what though, we are allowed to disagree with them. It's just funny because in this case it's like, that can't be. This is just one of those where we've gone through this before. All I can tell you is it doesn't pass what I call the come on test. Right?
Yeah.
Come on!
That's true.
You're leaving these guys out in the cold? Oh, come on. So it doesn't pass the come on test, in my opinion. Anyway. Okay, again, note 1, interesting. Government has to consent, right?
Mm-hmm.
Okay. We all know about the supremacy clause. So we could do that. I don't know, no duty to consent. I don't think that's true. Sorry. I think there's public policy. I like the dissent a lot more, just so we're clear. In my mind, they took it on. That's all I can say. I think that's the way I look at it. But I just think, what are we paying you for it? Right? See, I don't mind paying taxes, but I want my money to.
You don't
Does
get
that make
either.
any sense?
You don't get either.
You're making a big, beautiful wall. Shut up.
I don't want a wall. I want my money to. Okay? That's all I'm saying. This is too much. Too much. Sorry.
Yep.
Oh, this is an interesting one. Suits against officers who wants to do bandicam. Now we're in the Supreme Court. Hey, this is interesting stuff, I mean, right now, these are a lot of interesting issues about, governmental immunities and who can be sued and who can't be sued. criminals.
Oh, yeah.
Interesting
So-
stuff, really.
Basically, this one, a guy went to jail, but he only went to jail based on the very wrong information of a jailhouse informant that had LA or Long Beach created a system or trained their prosecutors. This informant would not have been used at his trial, and the evidence would have been given over to show when he had been used before. And so they tried to sue the actual district attorney, I think, his office, and saying that they're personally responsible for it because they didn't give over the evidence and they didn't. It was failure to supervise. And the court basically said that if a prosecutor is acting within their prosecutorial functions, you can't sue them because every prosecutor in the world would be sued nonstop and it would bring the entire system to a halt.
I have no problem with that.
Prosecutors would never make any decisions whatsoever.
No problem with all the tires coming to a halt. What I meant.
It's a legit.
So,
Like he wants the criminal justice system to stop. Oh my god.
He wants everything to
More
stop.
radical than I thought.
basically, when it comes to supervision of prosecutors, when it comes to just prosecutorial actions in general, they are all absolutely immune.
Pretty much. What do you think about that?
I mean, I agree, but I think there should be an exception
I think the only way
for
to stop
intentional
prosecutor
acts.
misconduct is to open them up to civil liability. I think that they should be. If they abuse their discretion and put somebody in jail, and if you can prove that like they knew or should have known that this was like improper, then I think you need to open them up to civil liability. I think it's the only way to really stop the misconduct that I think is happening on a regular basis. And I think it's a systemic problem in our culture that it's the only way to stop it. It's just to blow open the doors.
Because I mean, like some of these no cases that they have on it, it's just wrong. Like I think there was, it was like note 7 where the prosecutor failed to turn over a blood sample. They said that it was. They're not liable because, and it was intentional wrongdoing.
Like, they do things wrong.
And they're like, no, you're immune. I don't see why you should be immune. Like, if you open up lawsuits for intentional misconduct, you're not going to bring the system to the halt.
Right, I think so. I think all you do is you're going to get rid of a few bad actors, you're going to clean everybody up, and everybody's going to be walking tall and straight.
Yeah, that's how it should be.
That's what's going to happen. You know, everybody's going to walk around with their head up their ass for about a couple of years until they calm down and they realize that, don't do things on purpose.
Well, what do you
know?
about note 2? Just out of curiosity.
Note 2.
Look at that one. Because I've actually heard this come up a few times when the prosecutor.
Yeah, and see, I don't think that's right.
About that.
I mean,
they have liability for that.
See, I feel like they are kind of the counsel's office on how a police force does their job within the law for them to use evidence at trial. So if you are instructing the police on how to execute a warrant or if they should get a warrant or if there's some kind of an exception to the warrant rule that they can use, then that is part of their job function. Yeah, they may be mistaken, but if they're only mistaken, I think that falls under prosecutorial, like.
I think this is fine, because I don't think that they're acting within the scope of their duties as prosecutors here. I think a city attorney can do this, a private attorney hired by the police department can do this. It could be an in-house attorney for a sheriff's department. This doesn't need to be a prosecutor. And this is not a prosecutor's job.
But why? Because they're the ones that are going to use the evidence eventually.
So
they're the ones that know the.
But that's not the prosecutor's job is to take the evidence.
How can their job be that? I think the point of this case, though, is how can part of their job be creating false evidence?
Well, it's not part of
That
their job.
can't be.
It's not.
Well, no,
That's-
creating false that falls under the whole guise of intentionally fucking something up. And here, as long as they're acting, I'd say reasonably, I think they should be protected. Like if you tell them, like if a police officer comes to you and says, we want to get this evidence and yada, 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 and they can instruct them, no, you need to get a warrant or no, this exception.
So ask the
applies.
county attorney. That's what I would, if I were a prosecutor, I'd be like, why don't you go ask your county attorney? You know, there's like 500, there's like 50 of them over there.
Because the
Riverside.
county, because they're probably focusing on
Who asked the
civil
guy
actions.
who asked the guy who represents you? Don't ask me, the prosecutor.
But they're working on the civil action side of it. They don't know they may not know the criminal evidence code or what evidence is going to get thrown out in a criminal matter or fruit of the poisonous tree, whereas a prosecutor does. They know what elements of a warrant have to be there in order for that. Like Sue Seddon used to say, she couldn't even review warrant applications without opening herself up to liability. Which I think is dumb, because they're the ones ultimately who are going to use the evidence. And if you can only go back after the fact and say, why did you guys do it this way? I can't use any of this evidence now, instead of the police being able to go to them and being like, we need to get this evidence. Do we have enough probable cause, or do we need to do more investigation?
So you're asking the cops and the prosecutors to work together from the ground up?
Well, they should be.
I don't think that's the DA's job. I don't see the DA as like,
Well,
you know, like this is like this is not the Batman movie. You know what I mean? Like they're prosecutors. You know what I mean? And that's their job. They're not cops. You know?
okay, but let me ask you this question again, another interesting, because you know how much I love Scalia. But anyway, interesting case. But so okay, let's say by argument's sake that a prosecutor did manufacture some evidence or something. What's really the harm until it's introduced as trial?
Well, there is no harm.
To me, there's a lot of harm. To me, the warrant was wrong. The subpoenas were wrong. I mean, a lot of times your constitutional rights have been violated many times before you ever get, just being thrown into the system like that can really screw with your rights. You know, so I think the creation of false evidence is something that should be career-ending in the very least. And I think that the only way to enforce this stuff is to open them up to civil liability.
But you don't want them there to direct the police in the correct way to do it? You just want the police to mess around and get invalid warrants and do all that because they can't go ask them because they're going to open themselves up to
That's a good
civil
question.
liability?
Well, I'm okay with that, but then they're not acting. I think they should have their own, county attorneys.
But they're not investigating, they're just there to give guidance on, do I have enough probable cause for this warrant? Do I need to do more investigation? I mean...
But that's what the judge is for. They gotta go to the judge and ask that, right? The cops call the judges and ask, do I have...
Well, yeah, they do, but no, they call them to get warrants. I mean, and then the judges will say you don't have a probable cause.
Right.
But I mean, even still, I mean, you get a DA that's on call and you're like, you don't know whether there's an exigent circumstance to get in there, and so you're just gonna go in there anyways. And
I just think that if the cops and the prosecutors are really honestly treated as a single organization that are using each other for legal advice from the ground up, you create a behemoth that cannot be overcome.
is there any question nowadays that the DA and the police don't work together like that?
Well, I think that there's issues.
I mean, in what state?
I mean, you know that's how they do things in Europe, by the way, in the civil system.
Well,
That the judge comes in at the beginning and they work with the police, they work with the prosecutors, they work with everybody as a team from the beginning of the case to the end.
really?
Oh yeah. It's actually fascinating to watch them do it and to hear about it and stuff like that.
Well, like really?
Yeah. They assign a judge and the judge is like, what do you got for me today? And they're constantly running things back and forth between, the DA and the the defense counsel.
There's a defense counsel already in there before there's actually a criminal?
Yeah.
Really? So what does the defense counsel do? The defense counsel, that's cool. I think that's really cool.
Yeah. And the judge kind of tries to keep things kosher.
Well, instead what happens is that the prosecutor decides what evidence they will even tell the defense. And that is what the prosecution thinks that they can go get a conviction on. And whatever else they don't want to tell them, they don't tell them anything. That's the way it works now, and it's a disaster. With huge amounts of information on huge amounts of citizens just being collected and hidden.
Okay. I
mean, that's what I think.
Sure, I'm not gonna argue with you.
Yeah. But that sounds like a great way to do it.
Yeah,
way better
I
idea.
a way more, to me, it's a much more kind of comprehensive and
more holistic kind of style.
to me, it's much more interesting. And I think it's a better way to go. I think this cordoning off is I get the idea, but I think that, really when the judge is more like, involved in it and, if you're lying to the other side, you're lying to the judge. So you see how it kind of all, it has a better fit. I
Sure,
think.
that sounds great.
And you know where you stand, all the way through, basically. You don't have to wait till this Big Bang Theory event or anything like that. So I don't know.
Well, and also, there's no counsel now at all until you are accused of crime. And even then, you have to specifically request it.
Mhm.
And then you have to qualify for it.
Right.
So it would be great to have some kind of voice in the cops and prosecutors' ear that will have like some kind of confidentiality with them, but say like, no, you can't do that. You know what I mean?
Oh, yeah.
Like to have something other than go get them kind of mentality. I don't know. So that's great.
Well, again, it's not that their system's perfect, but it is interesting that they do have more of a referee role than they do here, really. They just oversee the trial, really, or over there they oversee the entire investigation. So it is interesting. You do know that there is waxing and waning philosophically going on in the Supreme Court today, that they want to hear a case that would challenge the right to counsel.
At all.
At all. Yeah, we thought this was kind of.
Okay.
Stay tuned. Who knows?
Yeah.
Anyway, so okay, 543 again for this case, and we can move on. But you get the idea that what they're trying to do here is they're trying to do an end around. They know they can't get the prosecutor, so they're trying to sort of tack on this tort idea about negligent supervision and things of that nature. And the court's just, it's an end around. You can't do that. I mean, obviously, we can't blame your supervisor. If you're immune, that makes no sense, right? So again, not a horribly decided case. I mean, that really doesn't make a whole lot of sense. That would be my opinion in this case. Now, the idea of just having immunity, that's a little bit different. Again, investigative activities, I think that's very interesting. Number 2, something to think about. Again, the civil system is very different. Not perfect by any stretch of imagination, but again, that's kind of how they do it. I don't know what I'm saying. Okay, creating causes of action. Okay, that's something that obviously the Supreme Court doesn't like to do, right? Put it that way. But Bivens versus 6 unknown named agents. That's a pretty cool name for a case, I have to say.
So here we have Bivens. He got pretty much swatted. The Federal Bureau of Investigation got into his house, like their narcotics division, and they kind of put him on the ground, arrested him. They threatened his family, saying, if you interfere, we're going to arrest you too. And all without a warrant or probable cause. And now he wants $15,000 each from each of them for his damages and his embarrassment, his emotions.
Okay.
And they try to argue that we have liability just because we violated his Fourth Amendment right doesn't mean we lose our immunity. But the judges didn't like that. They're like, no. It looks like he has a cause of action for when his rights are breached, so he should be able to recover money for any injuries caused by the breaching parties, the ones that breached his Fourth Amendment right, or violated his Fourth Amendment right, not breached.
Yeah, not breach.
Yeah, it's like not breach, they violated.
Violate or infringe.
They infringe his Fourth
Infringe
Amendment
is
right.
what it is. Infringe is damage to an intellectual property right.
Oh,
In case you're worried, whatever. Or any intangible right, civil rights are good too.
yeah, I just thought breach is breach the door when you're interested.
Yeah. Well, I mean, what do you think about that? I mean, what do you think about those? The one that always makes me really, really curious though, where when they show up at someone's house and it's the neighbor. It's not even my house, and they end up causing all sorts of trauma and damage and whatever else have you when you do that. Shouldn't they be liable for that?
Maybe not. It depends on a good faith issue. Like busting down someone else's door by accident is different than going into someone's house and
No, but even if you bust into the wrong door, you have to know which door you're busting into. It could be an old person that gets a
Don't you think that stupid? There's some room for stupidity.
No, there's no room for stupidity, man.
I do.
Investigation.
This class is really unique.
It's not room
I
for
believe in
Wow, I thought I was liberal. Good lord.
I believe in the mistaken belief that they're at the right house. Still getting over the fact that you think the prosecutor would be civilly liable if he told the police to go there, though. But the police should be immune.
No, that's not what.
It's okay if you get the wrong house. You're still gonna have to pay for the door and the old person.
I have to parse that out a little bit.
Well, no, you don't have to pay for it, though.
You're blowing a broader brush now from what I said.
Okay, well,
Yeah, if they intentionally, knowing it's wrong, tell you to go to that house and say that's okay.
I'm not saying intentional.
And same with the cops. If they intentionally go to the wrong house and go and beat somebody up, yeah, they should be liable for it. And so should the prosecutor if the prosecutor told them that that's okay to do. And so should the city attorney. The city attorney says that's okay to do.
I'm just going to read this.
Sorry.
Let's start this again. Petitioner's complaint alleged that respondents, agents of the Federal Bureau of Narcotics acting under claim of federal authority. Okay, so let's start here, okay? Entered his apartment and arrested him for alleged narcotic violations. The agents manacled petitioner in front of his wife and children. Wow.
Is she shooting with drugs?
And threatened to arrest the entire family.
This is knowingly wrong, right? This conduct you like one should know is wrong.
I'm just reading it out loud.
Okay.
Okay, for now. They searched the apartment from stem to stern. Thereafter, petitioner was taken to the federal courthouse in Brooklyn, where he was interrogated, booked, and subjected to a visual strip search.
There's no facts to say they had drugs or anything, right?
If they arrested him and brought him in, he probably had drugs in his house.
Does it make any difference?
No, because he didn't have.
Depends. If they had a good faith belief.
Okay.
I mean, this is 1971.
Everyone had drugs in their house.
Things were, rules were a lot less. I mean, even if it was without a warrant, I mean,
Might not try that with us. I'm not sure. It's not bad, I have to say. But Your Honor, that's what it's doing.
I mean, even if the search was effected without a warrant, that doesn't necessarily make it wrong.
Well, that's true.
I mean, there's just too much of the facts are cut out of the little insert that they give us. But I mean, if they just decided to choose that house because they had a vendetta against this guy and did all that, then yeah. But I mean, if there was exigent circumstances to let them go in there, they're federal agents, they can do that. I mean.
Okay. Well, I mean, do they have a right against the state in this case?
What do you mean,
Yes,
against the feds? Or
No,
against-
the Bivens. Does he have an action against the state?
Well, no, because they're federal agents.
Okay.
I don't know. I don't think that's what it's holding.
It does hold that he does have a
He does
right.
have one.
He has a right. He has a
According
constitution.
to the
federal government
petitioner
itself.
may obtain money damages to redress invasion of these rights only by an action in tort under state law in the state courts. So they think that they can be sued in state court. They're trying to sue under federal law, so they're trying to create a right that's not there. Did you all get that?
Wait, what is that?
Okay, yeah, that's right.
But the answer.
Okay, see, this case is a little more complex than it looks.
Okay.
Just so you know, okay, they can be, okay, according to the court, these agents can be sued in a state court tort action.
Oh, they're saying that there's no
But
federal
there's
law
no
that allows
federal
it.
law that allows them to do that, and Bivens is arguing that there should be.
And then the court just holds that it's been well recognized that the only remedy for a violation of a constitutional right is money damages. So the government has made it a not written rule that when a constitutional right is violated, you're automatically consenting to be sued. Or not? Because it says it's well settled that where legal rights have been invaded and a federal statute provides for a general right to sue for such invasion, federal courts may use any available remedy to make good the wrong done.
Oh, yeah, that's fine. Okay, I see what you're saying.
And it says historically damages have been regarded as the ordinary remedy for an invasion of a personal interest in liberty, which I'm taking as a violation of a constitutional right.
Oh, due process, okay.
So it says there's no explicit congressional declaration that persons injured by federal officers' violation of the Fourth Amendment may not recover damages from the agents But must instead be remitted to another remedy equally effective in the view of Congress. Just
But that's on the concurring, or are you?
No,
are you already? Okay, you're
still on the regular
Okay.
case.
Okay. So, well, okay, what is the actual, okay.
The violation of his Fourth Amendment rights. That's what he's suing for.
But usually when you sue for rights, what do you want? Usually.
Money. Or
I would say that's not true.
usually suppression.
Well, but what do you the plaintiff, so to speak, defendant or plaintiff suing for?
I mean, I think that all you get is like something like suppression. You don't usually get anything. I mean, what are you saying?
Well, usually you want an injunction. You want to stop it, first of all, right? Stop infringing on my rights.
Okay.
Therefore, after that, you might want to ask for money damages. But the cases, and we've already seen one, says, an infringement of your right is
Nominal.
It's nominal. So how are you going to go ahead and sue these guys for money damages? It's not like it's a written rule. You can't. But up to this point of Bivens, you really couldn't. Okay, so the point of this case is that this is a Supreme Court saying that in some instances, infringements of rights, right, at the federal level for money damages is possible. That's why this case is so big.
But doesn't Bivens effectively get superseded by one of these federal claims that says where they codified that?
I wouldn't say it was superseded. I would say it was codified though and changed to some degree.
Because I know they're in one of these 9 million notes. So yeah, Section 1983 says that when, oh no, that's just state officials. There was somewhere in here where it talks about they created a law for when federal agents. Oh yeah, Congress responded to Bivens by waiving sovereign immunity and making the United States liable for assault, battery, false imprisonment, false arrest, abuse of process, or malicious prosecution by investigative or law enforcement officers of the United States.
Right, so I wouldn't say it overturned it, it just codified it. So it modified it, but you can still get money damages, right? I mean, that's all Bivens says. It seems like this big sweeping thing, but it's not. All it's really saying was that up until this time, what the argument was is unless Congress has specifically said there are money damages available against these people for these types of acts,
Or you wouldn't
it
get
doesn't
anything. This
exist.
is immune.
Right.
Now they're saying
Now
that
they
you can.
codified it. You see how that all plays together?
But so what was the authority though for Bivens? I mean, under governmental immunity, they're immune.
Well, but
And then the court just says,
well, but they weren't even really saying they were immune. They were just saying the argument is that absent specific congressional approval,
then they're going to be sued.
they can't be sued.
Yeah.
This court said what?
That's not right.
Right. They said that's not true.
But why? I don't understand where the reasoning is that they come from that it's not true, other than it says historically it's been well regarded that ordinary remedies. I mean,
Well, let's see. This is the part I think. Let's see if this answers your question.
because on 556, it just seems like all they say is it's well settled that where legal rights have been invaded. But, it's a general right to, so are they saying that that there's a general right to sue whenever you're,
Well, the famous line from this case is it's right at it's 556 right at the end. The very essence of civil liberty certainly, and that would be your nothing else, due process rights. Certainly consists in the right of every individual to claim the protection of the laws whenever he receives an injury. And again, goes all with that. Having concluded that petitioner's complaint states a cause of action under the Fourth Amendment, we hold that petitioner is entitled to recover money damages, if they hadn't done that before, for any injuries he has suffered as a result of the agent's violation of the amendment. So here we have a situation where a federal agent is personally liable for money damages for violating the Fourth Amendment. that hadn't really, they sue state people all the time, but not feds. But then the idea though is, see, I like what you're saying, but I think it was more an idea of whether they had to wait for Congress to say it or not. Because if you read Harlan's concurrence, the very first part, he says the contention that the federal courts are powerless to accord a litigant damages for a claimed invasion of his federal constitutional rights until Congress explicitly authorizes the remedy cannot rest on the notion that the decision to grant compensatory relief involves a resolution of policy considerations not susceptible of judicial discernment. So in other words, he says, no, we don't have to wait. So, but until this day, guess what? It's what we did. So that's, I think, where I think that answers your question. So it's more of a separation of powers in a funny way, yeah? That makes sense? It's like, why, we don't have to wait for Congress, so we think there should be a right, and we're going to say there's a right. It is.
Is that only for constitutional violations? That right evolves?
Well, it's against the Fourth Amendment, so I kind of have to say yes in this case.
Because I mean, they're really the only ones where, I mean, Congress isn't really going to say, I mean, Congress isn't going to say, okay, you can sue us if we violate your amendments. The court just kind of has to be like, it's implicit that if you violate any one of the amendments, that you open yourself up to liability, because that is your document saying you have to follow it.
Right, and it's the same under the 11th, too.
Mm-hmm.
Under the 11th Amendment, for many years, it was thought the only really possible was an injunction. Recent case law, and it's like this says that's not true. There may be some instances where if it's appropriate as a remedy, they can actually, order money damages. So again, Fourth Amendment, 11th Amendment, that could happen now. But for many, many years, it really couldn't. It was thought that maybe you could sue the state, but not really, and certainly not a federal person in scope of their doing what they're supposed to do. But anyway, that's why it's a famous case, just so you know. But again, a little bit more particularized than that. So what we take though from this case is that in certain instances, it will be appropriate for money damages against individuals for violations of constitutional rights, so federal rights. Yeah, that wouldn't be all. Well, anyways, and then Congress after. So, okay, how about these? Now we got to ask ourselves what ones they didn't say. Can the court still fashion a remedy? And the answer seems to be yes, according to this case. But we'll see what happens. Of course, you always have to love a heading that starts or case. But is Bivens worse than trouble? Then you're going to start reading a bunch of different reviews. People. Okay, who wants to give me Armstrong versus Exceptional Child Center Inc.? Okay, keeping in mind this is Medicaid. Okay, this is a little different than Medicare.
So, is this where the doctors, this is that case, right?
Well, like that, didn't get paid enough.
Yeah, okay, find those facts exactly. Basically, doctors weren't being paid enough on, under Medicaid, and so they sued to try to get the, that reviewed. And, the issue was whether or not there even is a private cause of action under this. And the court held no in a really close 5-4 decision that basically that. How we talked? Shoot.
Well, this is okay. Remember that the section is about creating rights. So what right are they trying to create?
They're trying to create a private cause of action against the federal government for their decisions, basically regarding the cost of care, and they want to be paid a little bit more for their services.
Mm-hmm.
And the court that there actually is no private cause of action, just because they create an agency was going to set establish. I mean, I'm not clear whether or not these doctors are in some ways kind of required to take these patients.
Mhm.
They may be, in fact, a lot of times, you know, like Medicare for the elderly. If you don't take that, you know, you basically don't have any clients, you know, at least in an area like this.
Okay.
But I don't know about Medicaid. But yeah, so the federal government can put prices at whatever it wants, and there's not even a cause of action to review that. It seems like kind of an interesting decision.
Okay, so again, this case isn't terribly, it's just a newer edition of everything we've seen. The argument in these types of cases is, you know, Congress will make a law, right?
But
Now, the thing is though, a lot of times they'll make a law and it doesn't have, and it can pick its enforcement mechanism, right? Now, in this law, what happened is they said, but Congress didn't give a right to private people to enforce this law or state law. Therefore, who are we to say that such a right exists? Is that so?
yes.
Okay, so is that true in this case?
Yes.
Yeah, it seems to be true. I mean, in other words, if Congress wanted individuals to have a private right to enforce the federal laws against state law, they would have said so. Is that true? Sure, they do it all the time, right? They have enforcement sections of laws and stuff, and they can say that, just like we saw after the Bivens case, right? They said, fine, you're there. Happy now, right? This case, not so. There is nothing that says that there's an enforcement provision to this type of case, even though Medicaid, the federal law set the standards higher. They were still being paid according to state law, right? Is that correct?
Okay.
Yes, no?
Yeah.
I mean, again, the chapter's about creating rights. So in the case we saw earlier where, you know, basically the court says, well, we don't have to wait, right? Congress would have said so. You know, they would have said so. They said, well, that doesn't mean we can't do something. This case is exactly the opposite, isn't it? Like, no, yeah, we know this is here, but they don't have a private enforcement in their law, so why would we give it to them? Congress has spoken. Is that true? Do these cases seem at odd with each other?
Sure, but I don't really understand them, so I don't understand how. I mean,
Well, okay. First of all, it was in the Ninth Court of Appeals. 100%. But anyway, but this is the whole chapter is what they're trying to tell you is how rights. See, you always have, it's funny because there's a couple of kind of high-profile cases going through this right now at the Supreme Court level. But, you know, the question becomes, you know, what is the proper remedy for these things? And, you know, Congress makes the laws, and in cases like this, where, you know, you have a state law that's paying providers a certain amount, yet the federal law, and they accept Medicaid, and this state obviously says you have to pay a higher thing. But the problem is when they leave out a defense mechanism or an enforcement mechanism, either way you want to look at it, does the individual have a right to bring a suit under the federal standard? And the court said in this case, no. If Congress wanted them to have it, and so what they do is they kind of look through it and they say, well, look at the scheme, look how they laid it out.
but how does that hold up when, you know, every right must have a remedy? Like, you know, let's call it, every injury must have a remedy kind of a thing, you know?
Well, but remember, the question is, the question becomes in a case like this is, why did Congress make the statute? Was it to do this? Was it to do this? Or was it to protect individuals, providers who weren't getting paid? I mean, that's the basic bottom line of a case like this. And so what the court does, it's actually pretty interesting. They look and you think they just call them up and say, well, what did you mean? But they don't. They look at the actual statute itself. They probably look at the record. They probably look at, a lot of the stuff they write down, because they do write down. You can look and see a lot of the, Congress writes down what they're thinking. And so they said, so the question becomes in this case, was it the intent of Congress when they enacted this law to also give a private right to these providers for this type of violation where they're getting paid according to the state law, but they're not getting the higher rates under Medicaid? And they say, in this case, we looked at it and it seems to us from the, the legislative scheme, so to speak, or the statutory scheme, that they did not. And so they're not going to create a right where they don't think Congress wanted them to have that right. On the other hand, in Bivens, what did they say? It's inherent for them. We don't have to wait for them. So, interesting how we kind of look at this very differently. This is, about, 35, 40 years apart. You think that makes any difference? This is a very new case. And, notice that they put in, this seems to be Bivens seems to be a little more, let's just use the word liberal, decision. Whereas this case seems to be more conservative. They're just not going to put something in there unless Congress specifically, authorized it, or at least from their reading of the statutory scheme and record, at least indicated that they probably would have put it in there. Is that true? Okay, so again, this chapter really is, you guys are doing fine, don't worry, but again, it's about creating rights. Okay, so we do have to get a little more. And yes, it's quite difficult from time to time, don't get me wrong.
Note 8 also says that it's not an ideal teaching case.
Is it really?
Why
did they put it in there?
I have to absolutely positively agree.
Because it's the court's most recent word on this area.
Sure, fair enough.
Okay. And again, it's weird because we just talked about it. It doesn't say exactly the opposite, but it seems like it does. That's what I was trying to say, that it is pretty hard. Okay, again, another famous case, the right to jury trial, chauffeur local number 391 versus Terry. This will be our last case.
So basically there were...
You're lucky you did well on this.
There were two unions, actually one union with two locations of workers. The one location shut down, and so they all merged into one location. What had happened is that one location sided, and along with the union, with the old workers of that location. So all the workers from the other location were being laid off and fired and stuff like that. So they sued the employer under Section 301 of the National Labor Relations Act for breach of the collective bargaining agreement, and stated that they breached their duty to fairly represent them in the grievance proceedings. They originally sought injunction and compensatory damages, but ultimately they dropped the equity side of the case because the company bankrupt. So they ultimately were just asking for the compensatory damages, which was the lost wages and so the back pay and their health benefits that they were entitled to. They asked for a jury trial because under the 7th Amendment, they said that they should get one. The district court allowed them to get one, and the Court of Appeals affirmed. They said that normally an employee cannot bring a 301 action against the employer unless they can show that the union breached the duty. And they said that under the 7th Amendment, as long as the amount in controversy exceeds $20, they should have a right to a jury trial. They said that basically the union's arguing that this is a suit in equity, and because it's a suit in equity, they should not be allowed to have a jury trial. And
but why do they think it's equitable? Did anyone catch that? Why would you think that this would be equitable? That's the thing that kills me about this case. Is I would say to myself, back pay, that sounds like legal damages, doesn't it?
You said it in here somewhere.
Sounds like damage to me, so why do you think this is equitable in nature?
Because where damages are restitutionary in nature, they describe them as equitable. Because on Fed 76 it says, first, we've characterized damages as equitable where they are restitutionary, such as actions in disgorgement of improper profits. But then it goes on to say that And it also says that a monetary reward incidental to or entwined with injunctive relief may also be equitable.
Okay.
But here they're just saying that because that's all they're looking for now, it becomes legal instead of equitable, therefore they're entitled to a jury trial. And it's only because it gets separated from the equitable requests, I guess.
That's pretty close. That's
So,
actually really very close.
Had they kept
Very good.
the equitable claims,
Mhm.
they would not have been able to get the jury trial, but since they dropped the 2 equitable reliefs and asked only for the back pay, it all of a sudden became legal. And that's basically what the court is saying as far as I can read this.
Okay, that was a little off, but that was close. But you actually that was actually quite good because this is actually kind of it's a very odd case. I'll just put it that way. But let me just go through this for you again. Creating rights and stuff like that. But on 576, it's this, I think what's really important is,
They're not suing their employer, they're suing the union.
yeah, they're suing the union. But notice that they're suing under Title VII, okay? Now, the paragraph second from the end of the decision, Part B, I guess. The court has never held that a plaintiff seeking back pay under Title VII has a right to a jury trial. Okay, so they haven't really ruled on that yet. Assuming without deciding that such a Title VII plaintiff has no right to a jury trial, the union's argument does not persuade us that the respondents are not entitled to a jury trial here. Okay, so again, Congress hasn't said anything and they've never ruled on it. Now the problem though is Congress specifically characterized back pay under Title VII as a form of equitable relief. So they said, we're going to give you an equity. So Congress said so. It's not legal.
But that's only if they're suing their employer and not the union.
That's almost certainly true, yes. But Congress made no similar pronouncement regarding the duty of fair representation. So again, they're breaking off the right to a jury trial separate from the actual relief that's being asked for. They say it's a separate right. That's so? That's what it says. So what can I tell you? Congress made no similar pronouncement of fair representation. Furthermore, the court has noted that back pay sought from an employer under Title VII would generally be restitutionary in nature, in contrast to the damages sought here from the union. So you see there's a difference. They're making up the damages actually being different. So if they were going, you're correct. See, you just needed just a little tiny bit. I mean, you were just like, ah! But that's a little kind of weird because notice that they're breaking it into 2 separate rights. Jury trial is one thing. The equitable back pay is another thing. But then they cut it in half again. See, they say, we might have a problem though if it was against the employer though because however, they're asking for a different type of damage. The union wasn't directly responsible for the back wages.
They're just saying because of the union's unfair representation, that's
So
why
it's
they're responsible
damage.
for it.
Good move. And that's not what unions do. They're supposed to protect them. So it's a very different type of damage, is that so?
Mhm.
They're not paying from an employer? Okay, and can we reasonably say that the damages, the money, is different than the right to a jury trial? A reasonable assumption, right? I mean, you can say those are 2 different rights. So, and I think under this case, it actually kind of a technical case, but it kind of makes sense. I mean, the type of damage that the union caused is really not, I don't see it as being equitable that they would have to, base an award on back pay. That's just a good number. Why not use that one? That's a smart attorney, if you ask me. Of course, he had to go all the way to the Supreme Court to get it. But this is one of those cases I love because an attorney thought it through. Now, he was also beyond lucky, to be honest with you. When all there's a Supreme Court, he wins. But he thought it through. It's a good case. It really is. This is one of those ones that I'm like, that's a very clever attorney. Very clever attorney in this case. So we're all going to be clever attorneys one day, right?
Yes.
Right. I already had my shot. I don't think anyone else will be clever, unfortunately. But I came out with my skin intact. I'm happy.
That's all that matters.
Pretty much so.
And you didn't die in an OSHA violation, fryer fire.
No, I didn't. So even better. All right, we good for today? I know Will's good. He's already back up. So
Yeah, sorry, I'm at bedtime already.
it's okay. Answer. I'll leave you a little time.
It's only 7:47.
But you guys did pretty good. You guys, you did, everything being equal. Not bad. Yeah, I mean, I'm not gonna keep you up at night. Not like those class over there.
Bad rules of law.
Yeah, but it's really interesting because, again, we're gonna be, in case you guys haven't really, being law students, you don't get to watch the news all the time.
Yeah.
But a lot of these issues, the good, the bad, and the indifferent, is we're gonna find out very soon whether the President of the United States can be indicted for criminal acts while he's still in office. We're going to find out. And there's gonna be a lot of other stuff that's gonna trickle down from that. Very interesting stuff. Anyway.
Thanks for down.
No problem. Wait. All right. I already did it. All right, so, okay, class, good job.
Thank you.
Our little technical class.
See you Saturday.
Yeah.
More likely than not. Oh no, it's an MCLE this Saturday. Isn't it? Yeah, I think it's negotiated at the pros this Saturday.
Oh, okay.
I don't know. I know it's one of these weekends coming up.